you have 1 minute left. So they will follow each other, and then after that, we'll have a question and answer session after they have all presented. And then I will give the speakers 1 minute each to just wrap up their thoughts. So as you have seen, the titles range from girls' rights, broadcasting, media freedom, evidence, and regional standard settings. And the title of this session this morning is Landmark as Calibration. Our speakers, we have Marianne Kechi Obiak Bayoso and Dr. Olainka Adeni. Then we followed by Christian Aime Chofoche. He told me I must say Chofoche, like the African way. And then we have online Solomon Fakia and Ernest Ako. I think Solomon will be the one who's presenting. And last but not least, we have Chidi Celine Odingalu and Ikechuki Uzoma. Ikechuku will be the one presenting, and he's here with us. So let's start with the first presenters. I hear she's online. Yes. So let's start with you, Marianne. 15 minutes. Thanks.
Thank you, Jozo. I want to share my screen. I don't know, I'm unable to share my screen.
Mary Ann, screen sharing is enabled for all participants. Please try again. Are you logged in from a cell phone or from a desktop?
From a phone. It says unsupported document type.
That is a technical and a hardware issue on your end that we can't assist you with. Perhaps try logging in from a desktop.
To save time, let me proceed without the slide. Apologies. But I shared the slide. I don't know if it can be projected from your end.
Yes, it can.
Okay. Good morning, everyone. I am Mary Ann Nkechi Obiaboso. I'm a doctoral researcher with the Center for Human Rights, University of Pretoria, and I'll be presenting a paper I co-authored with Olainka Adeniyi. She's a postdoctoral fellow also at the Center for Human Rights, University of Pretoria. Our paper is titled A Landmark for Girls' Rights in Africa, APDF and IHRODA against Mali, and the Jurisprudence of Socioeconomic Justice. The full name of the case is the Association for the Advancement and Defense of Women's Rights, APDF, and the Institute for Human Rights and Development in Africa, IHRD, against the Republic of Mali. This is the first continental judgment directly tackling child marriage, and it shifted the conversation from individual complaints to forcing states to change laws and social norms. The applicants are both non-governmental organizations who filed an application against the Republic of Mali before the African Court on Human and People's Rights in the year 2016. The main issue is some of the provisions of the Persons and Family Code that was enacted by Mali in 2011. Prior to the promulgation of this law in 2011, the Persons and Family Code was initially drafted in 1998, and it made the age of 18 the minimum age for marriage. In 2009, this code was adopted, but it experienced and received series of oppositions and backlash from religious and traditional leaders because the content was not in line with their cultural and religious inclinations. Due to this tension, the government of Mali was forced to revisit this code and amend some of the provisions to be in line with the demands of the people. And this led to the 2011 code, which sets 18 years as the age of marriage for boys and 16 for girls. And in special circumstances, these children can be married at the age of 15, while for boys, they can be married at the age of 15 with the consent of both the father and the mother. But when it comes to girls, it requires just the father's consent, not the mother or the father's consent jointly. So as a result of this, the applicants concluded that the provisions of the family code violated some of the fundamental rights of the children, most especially girls, which are enshrined in international treaties, and is against the obligations of the states. They brought a series of claims before the courts, among which are asking the courts to declare the age of 18 as the minimum age for marriage for all. And also another provision in the family code is the requirement for verifying the consent of parties to a marriage that is to be celebrated in the civil marriage registry. While for marriages that are celebrated within the Islamic domain in the mosques, only parental consent was required, thereby forcing girls to be married without their consent first sought and obtained, even when they are of age. This case matters because Mali has the 5th highest prevalence of female child marriage globally. According to UNICEF, 3.5 million women married before age 18, 1.3 million before age 15. And the 2018 Demographic and Health Survey of Mali also indicated that 53% of women aged 20 to 49 married before age 18 compared to 3% of men, showing the disparity between women and men when it comes to marriage. And there are several drivers that led to this, and some of which are poverty, low literacy, discriminatory gender norms, and weak enforcement procedures. And this goes against the aim of meeting the SDG Goal 3 and 5, which seeks to end harmful practices, integrate SRHR into national strategies. And African states, including Mali, has made series of commitments to ensure the eradication of child marriage and protect the rights of girls. Now, for us, why do we consider this case a landmark judgment? For us, we are looking at it from a legal perspective. We see a landmark case as an important court decision that initiates a new principle of law, alters an existing principle, sets a principle for lower courts to follow, and reframes the interpretation of legislation and constitutional rights. It's all about judgments that seeks to change provisions in national laws and bring them in line with international norms and standards. Because we've seen cases where countries try as much as possible to embed provisions that are against the human rights of people in the law and claim that these laws are enforceable since they are embedded in the provisions of the nation. So this is why this case is important. And we also looked at some of the cases that have been decided at the national level that are considered landmark judgments. In response to the application brought by the applicants, the Republic of Mali, who happened to be the respondent state, did not deny the claims of the applicants. Rather, they came up with defenses and excuses to justify why they had to derogate from their international obligation and fulfill the mandate of the religious and cultural leaders by embedding provisions that violate the rights of women and girls. They also claimed that in 2009, the crisis in the country, the oppositions, the protests against the provisions of the previous family code made the state to adopt a law that meets the needs of the people as against their international obligation. While this meant it had to adopt its legislation to reflect cultural and religious realities, also, the respondent states raised through preliminary objections, challenging the court's jurisdiction and admissibility, arguing that the claims related more to sensitization and harmonization than to interpretation of the African Charter, and that the application was not filed within a reasonable time under Article 6 of the protocol. The court had to decide on the jurisdiction in order to address the objection raised by the respondent states. On the issue of material jurisdiction, the court held that the court has the power to interpret the African Charter and any treaty Mali ratified, including the Maputo Protocol and CEDAW. For personal jurisdiction, Mali had signed the Article 34.6 declaration, which allows NGOs like the applicants to file directly before the African courts. And for temporal and territorial jurisdiction, the court held that the violations happened after the treaties took effect and happened inside Mali. Therefore, the case could proceed. In this regard, the court decided on the admissibility that was also raised by the respondent states. The court rejected the objections raised by the respondent state and held that the applicants could not resort to local courts before approaching the African courts. And this is because the constitutional provision of Mali did not allow non-governmental organizations to challenge constitutional provisions within the country. As such, the applicant had no other choice but to go to the African courts to seek redress. And on timing, the court also decided what reasonable time meant. The applicants brought the application 5 years after the promulgation of the Family Code. And the court also held that the application was actually brought within time because the applicants needed time to study the application and amidst the tension that was also in the country to understand the treaties that applied before bringing up an application before the court. And as such, it held that the application was admissible and could hear the matter on merits. The court raised 4 issues. However, this paper focuses on 3 major issues that are directly connected to the issue of child marriage. The first is the right to non-discrimination and equality, the right to autonomy, and the right to protection from harmful practices. For the right to non-discrimination, the Family Code has these varying provisions regarding the minimum age of marriage, and this is considered a violation of the right to protection from all forms of discrimination because it disproportionately disfavored girls as against boys, and also the requirement for parental consent when it comes to boys and the parental consent when it comes to girls are all forms of discrimination. The right to autonomy, the issue of consent, where consent of parties are not required to contract a marriage in an Islamic institution, also amounted to a violation of the right to autonomy because it denied these girls the right to give free and full consent to marriage, even when they are of age. The right to protection against harmful practices. The Family Code embedded provisions that promoted child marriage, discrimination against girls, and carrying out marriages without their consent. And all these are various forms of harmful practices that should not be in a law that has ratified international human rights instrument that sets the norms and standards for rights. The court made a series of orders, among which are ordering the respondent states to amend the Family Code and set the minimum age of marriage at 18 for all without exceptions. And also for Mali to harmonize laws with Maputo Protocol, the African Charter on the Rights and Welfare of the Child, and CEDAW, and also to carry out sensitization programs on the dangers of child marriage and report on actions taken to achieve law reform. And looking at the jurisprudence of socioeconomic justice, the APDF and IHRODA against Mali judgment advances a jurisprudence of socioeconomic justice by linking civil rights to the material conditions that shapes girls' lives. The African courts moved beyond formal equality to address how poverty, low literacy, discriminatory gender norms, and weak legal enforcement converge to entrench child marriage. By striking down Mali's dual age of marriage and parental consent loopholes, the court recognized that socioeconomic inequality is not a backdrop to right violations, but the mechanism through which discrimination operates. The decision grounds socioeconomic justice in 3 folds. First, it frames child marriage as a structural harm that violates the right to non-discrimination because girls bear disproportionate health, education, and economic costs. Second, it ties autonomy and free consent to real choice. And this is because consent is meaningless where poverty and patriarchal norms remove girls' bargaining power. Third, it orders structural remedies, such as law reform, sensitization, training for religious ministers, and rural access to notaries, thereby shifting from individual compensation to systemic change. Thus, this judgment treats socioeconomic justice as inseparable from human rights. It holds states accountable not just for repealing discriminatory laws, but for dismantling the poverty and cultural norms that make those laws harmful. For us, landmark judgments like this permanently expand jurisprudence by demanding enforcement and social norm change. and not just the change in the legal text. This judgment is also a landmark judgment, and it's important because it has impact in different areas and in different sectors. First, it is the first African court judgment directly ending child marriage. This ruling stands out as the first historic judgment where the African court interpreted and directly enforced the Maputo Protocol. It also has long-term impact on women and girls. Aside promoting and protecting their rights to be free from all forms of discrimination, recognizing their right to autonomy and protection from harmful practices, it also solidifies the need to advance the sexual and reproductive health and rights of adolescent girls. Because when they go into child marriage or forced marriage, they experience sexual violence, maternal mortality, and childbirth complications such as vaginal fistula. So this law protects them and ensures that girls are not married off before 18, and that before they clock 18, they have access to adequate education. For sovereign governments it has impact in the sense that the governments are now held accountable for the obligations that they have at international level. They are supposed to ensure that the domestic laws are in line with their international commitments. For non-governmental organizations, it's now an opportunity for non-governmental organizations to approach courts to challenge provisions of different laws at national levels that are not in line with international standards, and to carry out advocacies to ensure that where judgments have been passed, that implementation is also achieved. It also has impact on religious and cultural leaders who are the upholders of these cultures that perpetuate all forms of right violations. It also supports their sensitization to make them understand that cultures and traditions that violate the rights of people should not be promoted, but rather should be dismantled. In conclusion, the APDF and IHRD against Mali is applauded because it puts girls' sexual and reproductive health and rights above cultural and religious arguments. The court reaffirmed that states have a clear obligation to end child marriage through law, policy, and education. But as we argue in this paper, the judgment also asks us a hard question. Can law change practices that are deeply rooted without changes on the ground? The court gave us the legal tool. Now, governments, civil society organizations, and communities must do the work to ensure that this judgment moves from being a judgment on paper, but to see actual implementation on ground through law reforms. Thank you.
Thank you. Thank you very much, Mary-Ann, just on time. So our second speaker, please. Just the one? Okay.
Good morning, everyone. Good morning, profs. Good morning to the organizers, and for making us enjoy so much yesterday that we overslept today. So I'm Christian, Chofo Chair from Cameroon, a serious family member of the center for many years. That's the introduction I'll give for myself. So the paper I'm presenting this morning is The Right to Broadcast, Press Independence, and Media Freedom in Africa, examining the landmark significance of Open Society Justice Initiative versus Cameroon. Now, the roadmap will examine the case, why it's a landmark case, and we are going to use 4 grounds anchored by a replicable 2-part test. Then it will be important to throw some light on comparative perspectives, in as much as we are trying to decolonize jurisprudence of the African human rights system. It's still a young system, so we still have to draw inspiration from the inter-American system as well as the European systems. Then it will be important to have a critical condor, the decisions limits and the compliance gap. Then we'll proceed with recommendations before a conclusion. Now, the facts of the case. Now, this is a case which involves a prominent journalist who passed away, unfortunately, in 2009. He founded a radio station, Radio Freedom FM. His broadcasting license was arbitrarily refused with no legal basis offered by the government of Cameroon. And in May 2003, the premises of this radio station was forcibly closed, equipment seized by the authorities. Now, with the complications with exhausting local remedies, this case was filed before the African Commission in 2007. And as most of the cases that we have examined as of yesterday, the case was decided on the 18th of September, 2019, more than 12 years later. Now, the Commission's ruling. The Commission found that 4 charter violations were not respected. First of all, general obligations, Article 1. Cameroon failed to give domestic effect to charter protected rights. Article 2, non-discrimination. The licensing regime was enforced selectively against this applicant. And thirdly, freedom of expression. Arbitrary license refusal amounted to an impermissible prior restraint. And Article 14, the right to property, the unlawful seizure of the radio premises, and as well as equipment. Now, why does this decision qualify as a landmark status? I argue this on 4 grounds. First of all, the doctrinal consolidation operationalizes broadcasting licenses governance order Article 9. Secondly, judicialization of soft law gives binding effect to the 2002 and 2019 African Charter on People's Rights Declarations of Principles. Thirdly, the anchor of these 4 grounds, a replicable 2-part test, which requires a statutory basis and a structural executive independence, which warrants that in such operations, it's important that the executive stays off. And fourthly, continuing sociopolitical relevance. Licensing regimes remain tools of political control across many African states. So it's important to lay some emphasis on the anchor of these grounds, which is the 2-part test. Firstly, the clear statutory basis. Restrictions on broadcasting must rest on specific legal provisions and not informal ministerial discretion. And secondly, structural independence. Licensing authorities must operate independently of executive control. So this is the anchor of the premises for the landmark issue. Now, as I earlier said, in as much as we are trying to decolonize jurisprudence of the African human rights system, if I may use the word Ubuntulize the system, it's also important that we draw inspiration from systems that have made progress than our young growing system. So I drew inspiration from quite some examples, specifically from the Inter-American Court with the Grenier versus Venezuela case. And the point of convergence there was independence and transparency in licensing decisions. There was also the case of Información Lancia versus Australia in the European Court of Human Rights. Also Central Europea 7 versus Italy. For the issue of time, we will not go into details of these cases, but I think these are cases which would go a long way to give impetus to our growing system. Equally, we have the expression now versus Nigeria, the ECOWAS Court of Justice, which adopted and extended the Commission's two-part test. Now, what sets this decision apart? So the key contributions. First, on governance, not just principle. So this, as I argue, is the first Commission ruling addressing the specific governance of broadcasting licensing bodies beyond the general press freedom principles set in earlier cases, such as media rights, agenda in Nigeria, as well as Ghazi Suleiman in Sudan. Secondly, an analytically novel combination. So it's quite a novel combination with respect to structural, procedural, and anti-discrimination findings, which were brought together under a single case. And then thirdly, Article 2 as a standalone tool, selectively enforce licensing regimes, violate non-discrimination norms independently of Article 9, a doctrinal tool for challenging media repression across Africa. In as much as we argue that this is a landmark case, it does have its limitation, and it was important to include this, an honest account of limits, the critical conduct. So the first issue, it consolidates rather than invents the standards it applies. Secondly, does not address substantive, only formal independence. Thirdly, remedial orders fail to dismantle the licensing framework found incompatible with Article 9. And as of May 2026, as well as we can say June, Cameroon had not yet complied with any of the Commission's orders. So those are some gaps which was necessary to make mention. So beyond compliance framework, it was important to draw inspiration on some scholarship on this issue by Helfer and Slaughter, and also from our renowned Professor Vigneault here, seated and Louis. Non-compliance does not negate normative significance. In as much as we have these gaps, the two-part test still functions as a benchmark for civil society advocacy, as well as sub-regional judicial citation. So from all that we have looked into, it was important to propose, some recommendations on how the Commission could move forward, especially with respect to similar cases in the future. First of all, the issue of the 12-year plus gap, filing a case in 2007 and deciding on it in 2019, that is something which the Commission needs to really look into, as with respect to other cases, so that it gives credibility to the work that they are doing. Secondly, other structural remedies, not only individual restitution, as was done in the Inter-American case of Grenier and Venezuela. Thirdly, build binding follow-up mechanisms. As you have noticed, I'm very particular about implementation. And it's important that we have follow-up mechanisms to ensure that proposals from the Commission and other African human rights bodies are implemented. Another issue I recommended was clarify post-mortem standing for reparations. In as much as, remedies are directed to, those who submit cases before these African human rights bodies, and the eventuality that they pass away, it's important that the Commission looks for a way to give these reparations maybe to the next of kin, with respect to certain conditions. And then I also proposed, well, it may be an ambitious recommendation, the need to extend this two-part test to digital broadcasting, not only to conventional broadcasting. So in conclusion, a landmark judgment need not be complied with judgment. Its significance lies in the standards it sets. So Cameroon may have ignored the ruling. Courts and advocates across Africa do not have to. The standard survives even when compliance fails. Thank you for your keen attention.
Thank you very much. Also on time. So we're very good at keeping time. Is Solomon in? Because earlier he was not there.
Yes, I'm in.
Okay.
I'm in.
All right. Over to you, Solomon.
I'm
Thanks.
in, yes. Okay. Thank you very much. Let me attempt to share my screen. And to the extent that I'm just, yes, I think I can. Do you have it?
Yes.
Okay. So I can now proceed. I'm doing this presentation. The work was done together with Dr. Ernest Aku. Both of us are lecturers at the Faculty of Law at the University of Cape Coast, Ghana. I'll try to be very brief with this presentation. So the context of this presentation is the famous case of Commission for Human Rights and Good Governance in the United Republic of Tanzania, hereinafter referred to as the albinism case, just for convenience. So I'll proceed, look at the facts in outline. The case concerned widespread attacks against persons with albinism in Tanzania, including killings, mutilations, and trafficking in body parts. These attacks were driven by harmful beliefs that albino parts have magical or ritual value. The applicants argued that Tanzania knew of these recurring violations, especially between 2008 and 2017, but have failed to prevent or effectively respond to them. The court therefore held, among others, that the state bears a positive obligation to take reasonable and effective measures to protect persons at risk from foreseeable harm by private actors, including persons with albinism. The court further held that Tanzania failed to exercise due diligence in preventing, investigating, and prosecuting attacks against persons with albinism, thereby breaching its obligations under the African Charter. Now, we make three core claims in this presentation. One, that progressive and expansive interpretation of the rights regime under the African Charter was achieved through this judgment. Two, that this judgment substantively recognized structural harm and transformative remedies against persons of albinism. And three, we make the ambitious claim that there's room for improvement when it comes to procedural elements. That is when it comes to the court recognizing the duty or burden of states to keep and where necessary produce disaggregated data as part of the trial process. So these are three core claims to make. So claim one, we argue that this case presents an expansive interpretation of the African human rights regime. And why do we say so? We start on the premise that international human rights law in general We are talking about the African Charter, the ICESCR, the ICCPR systems. All these already recognizes discriminations on what we are calling the traditional heads: race, sex, gender, disability, and the so-called other status, which is an omnibus head of discrimination. So courts have open-ended categories, not closed-ended in the strict sense. But other status can be contextualized and further developed. And here we are saying that we see a unique development of the heads of discrimination under these judgments. First, we are saying that there is a recognition of intra-group phenotype vulnerability, which, in our view, is an extension of the court reasoning when it comes to heads of discrimination. The court made intra-group phenotype-based vulnerability actionable within law, showing that harm can arise from visible genetic difference within the same racial community, not just traditional categories like race or ethnicity. And we find that very interesting, because the regime for race and the regime for ethnicity and the regime for disability does not neatly fit into the unique facts of albinos. And this recognition, of course, add further flesh to the so-called other status category within international human rights law when it comes to the heads of discrimination. We further say that we see a context-sensitive adjudication here. The case reflects strong judicial agency in responding to a distinct African vulnerability. We must see that the facts of the case show that persecution against albinos was a unique trend within Tanzania. And that shows the court sensitivity to context. The court recognized that albinism in Tanzania was widespread, making the harms faced by persons with albinism systemic rather than isolated. It acknowledged that these harms were shaped by stigma, racial violence, and material deprivation. The judgment is landmark for showing the court's willingness to adapt human rights protection to African social realities, and in this case, within the specific realities of Tanzania. Because human rights law must not just be proactive, but must also be reactive, in fact. And where you see human rights adjudication, that is responding to specific context, that is progressive. We are saying that the duty to prevent harm was also further extended. The court's reasoning amount to, and we look at the duty to prevent the harm through the lens of structural vulnerability. It reaffirmed that due diligence is not limited to responding to isolated incidents, but extends to preventing foreseeable patterned violence against groups. And in many common law countries, we know that claims, the floodgates doctrine, limit claims when it comes to groups making a claim for injuries before courts, especially in the law of torts. This is very interesting, where the court is very willing to recognize and to enforce harms against groups without averting attention to even the concept of floodgates, where to draw the line when it comes to these claims and so on and so forth. So this is also something that we talked about. Recognition of structural harm. We say that the case uniquely recognizes structural harm by exposing how violence against persons with albinism is socially produced. The social production of harm, that where there is systemic harm, of course, the court must be prepared to respond to harm that is created by social structures itself, and must provide interventions that are also embedded in the very social structures that produce this harm. And we see this in the Tanzania judgment. So we see we rely on Gattu's famous formulation: structural violence exists when social arrangements systematically disadvantage certain groups, preventing them from meeting basic needs or achieving full human potential, even without a direct perpetrator. So these are the structural components. This violence was rooted in belief systems, societal belief systems, the belief that albino parts would, of course, give them wealth, healing powers, and so on and so forth. But the state failure to protect albinos through effective policing and the state ineffective protection measures. This is where we talk about the structural components, that the harm was socially produced. And that meant that the court had to prescribe interventions that required social action. So the court provided a repertoire of structural remedies, preventive, curative, and continuous. And within this framework, this repertoire, it is our argument that there is some innovation, which we'll argue in the main paper, that the court remedies itself were transformative because it brought together a repertoire of preventive, curative, and continuous remedies. And I have listed some of these remedies here. I've listed some of these remedies here just for your guidance. I've listed some of them. So we now move to our third claim, room for improvement. And here we make some ambitious claims, which is giving flesh, will be giving flesh in the main paper. But we rely, for example, on Article 31, which imposes a duty on state party to collect appropriate information, including statistical and research data, to enable them to formulate and implement policies. The basis of this argument simply is that the court should have shifted the burden of proof in significant ways. There was much opportunity. There was enough grounds for the court to have fixed Tanzania with the responsibility to produce data in relation to data relating to population of albinos, patterns of killings, patterns of mutilations, actions that they have, specific actions that have been taken in response to their specific obligation. Of course, we bring this caveat. We are not saying that albinism fits neatly into disability. No, we are not saying that. But we have shown the extent to which it overlaps and how a functional disability thinking or approach makes the CRPD, for example, a duty to collect disaggregated data and maintain disaggregated data on disability relevant here. And we have also made reference to other international instruments and their interpretation, which impose a duty of state to keep such data, to produce such data where required. We think that there was much more duty on Tanzania, looking at the procedural aspect of the trial, to indeed prove the case in some ways, especially show that they have fulfilled their responsibility regarding the protections for people with albinos and so on. So, although the court recognized widespread violence against persons with albinism, it relied heavily on NGO and external reports rather than interrogating the state's own evidential duties. It did not formalize a burden-shifting framework. Once credible patterns of this were established, it left the evidential asymmetry between applicants and the state unresolved. The court accepted that harm was systemic, but did not require the state to produce disaggregated institutional data to test its compliance. The decision of Center for Human Rights and United Republic of Tanzania is landmark in recognizing structural violence against persons with albinism, but it still leaves room for a more robust evidential and remedial framework to fully address systemic harm. The sweetness of this paper, of this presentation, will be in the main paper. So certain aspects have not been fully captured here, but this represents in some the essence of our thinking. Thank you very much for the audience.
Thank you so much, Solomon. Our last speaker.
All right. Good morning, everyone, and thanks to the speakers who've gone before me for those great presentations. So there's a country called Western Sahara, and there are a people called the Sahrawis. They are currently under the colonial occupation of another African country, Morocco. And this is what I call Africa's most prominent stage of colonialism. When the African Court on Human and People's Rights was confronted with this situation, it pulled on culture, law, religion, and then politics and diplomacy. It insisted on engaging with the problem, though understanding the threats it faced to its existence and the political headwinds against it. However, armed with its protocol, the rules, the jurisprudence, and sheer will, I would say, it made the following declarations in the final paragraph of the operative part of the 100 pages of this decision. As you can see, it says that the respondent states, and indeed all state parties to the African Charter and the protocol, as well as the members of the African Human Rights, okay, I think the slides are mixed up. So I'll just go with the slides. Okay, so when the African Court was faced with this question, it deduced one main issue for determination, and that's what you have on the slides. And it said, considering the facts of the case and the submission of the parties, the court is of the view that the application is essentially and firmly linked to the right to self-determination, and in particular, Article 20, sub 3 of the Charter that provides for all peoples to provide assistance to people under foreign occupation in their struggle for freedom. And that's what Article 20, sub 3 of the Charter says. Now, the key determination, which is what I referred to earlier as the last paragraph of the operative part of the 100-page decision, says, amongst other things, that all states and all member states of the African Union, including Morocco, have the responsibility under international law to find a permanent solution to the occupation and to ensure that the enjoyment of the inalienable right of self-determination of the Sahrawis, and not to do anything that would give recognition to such occupation as lawful or impede the enjoyment of those rights. My name is Ikechukwu Uzoma, and I am senior staff attorney at the Robert and Ethel Kennedy Human Rights Center, but also the co-chair of the Arusha Initiative. I want you to remember what I'm going to say next. I am Igbo. Igbo is a tribe in southeast Nigeria. I would share why I said that at the end of the presentation. And I'm honored to make this final presentation in the landmark section of this conference, because I believe that this decision is the most landmark decision of the African Court. And I hope you agree with me at the end. And this paper I've written with Professor Chidi Odinkalo, who is also Igbo. The facts of this case. In 2018, Bernard Morna, a citizen of the Republic of Ghana, brought this case before the African Court, challenging the inaction of the respondent states with respect to Morocco's application to be admitted to the African Union. The respondents in this case were all the states who had subsisting Article 34.6 declarations at the time: Benin, Mali, Malawi, Tunisia, Tanzania, and the others. As you all would know, the outcome of the infamous Berlin Conference was the partitioning of Africa with no respect to culture, no respect to our identity, no respect to the shared values that we had. And what ended up being called Western Sahara today became a portion of Africa that was ceded to Spain. At the end of Spain's colonial rule of Western Sahara, they came up with something called the Madrid Accord, which bequeathed Western Sahara to Morocco. So one colonial power, by some form of an accord, bequeathed a territory of the Sahrawis to another country. Of course, the Madrid Accord, which was determined, or which was signed in 1976, was vacuous in light of the 1975 opinion of the International Court of Justice on Western Sahara, which determined, amongst other things, that Morocco has had or has no historical ties whatsoever to the territory of Western Sahara. It was in this context, the context of Morocco claiming ownership, or at least historical ties to Western Sahara, that the OAU admitted Western Sahara, or the Sahrawi Arab Democratic Republic, to the organization. The OAU accepted the Sahrawi Arab Republic as the representatives of the Western Sahara people and admitted them into the Organization of African Unity. And because of that, Morocco left the OAU in 1984. Now, it's in the context of Morocco's decision to return to the African Union that this case was filed and the cause of action arose. But permit me to pause here to speak a bit to my concept of landmarkness. And I would adopt a mixture of some of the understandings from yesterday, Professor France's etymological definition of landmark, Dr. Mutangi's subject analysis approach, but as well as my friend here, Joshua's reference to the scholar's approach as part of that subject analysis approach. And so for me, in addition to all of those, I'd like to add the mechanism perspective, which in this case is the African court. And by that, I mean that if the mechanism that produces a decision determines that that decision is landmark in its decision, then maybe we should identify it as landmark, because that the mechanisms are the closest to their decisions, while the victims are the closest to the facts. The mechanisms are the closest to the decisions, but not just the decisions, but also the extrajudicial considerations that led to the decisions and how they turned out. So I also love the jettisoning of the ratio and obiter dichotomy, and would adopt a contextual analysis to understand to the extent possible what the intention, the motivation, and the constraints of the adjudicatory mechanism may have been in issuing the decision. So let's go to the landmark aspects of this case. And I would like to start with the victim's perspective. Following this decision, the victim, or at least one organization representing the victim or the survivor group, released a statement and stated clearly that the African court ruled for the Sahrawis. In 2023, I was here and I participated in a conference organized by the Center for Human Rights, where a representative of the Sahrawi Arab Republic also joined to discuss this case. And he had all good things to say about the decision. That tells us something about how it's received, at least by the victims. Now, before I get there, one indication of how the court perceived the decision you would find in the body of the decision, especially with respect to what the court says about the number of parties that they had in that decision. And here the court said in paragraph 205 that this case was the first of its kind because of the number of parties and the nature of the submissions filed. And therefore, I conclude that this is both a landmark case and a landmark decision. And here is a full complement of the paragraph that I shared earlier, when the first paragraph I shared where that I said was the last operative paragraph of the decision, I'd like to share a few lines above it to give it context. The court said that having held that the respondent states have not violated the rights of the Sahrawi people, the court nevertheless reiterates that the respondent states, and indeed all state parties to the African Charter and the protocol, as well as member states of the AU, have a responsibility under international law. And then the passage I shared earlier continues. So the court actually did not find a violation against the respondent states. And I think the question in your mind is, so why is it landmark when there was no finding of a violation? Now, this reveals the first landmark attribute of the case, which is the constitution of the parties. And I would have loved to go through it, but we don't have all the time. But just to mention that one of the parties, Tunisia, by the time Morocco made its application to join the AU, had not made its Article 34.6 declaration. However, the court held that because the court pulled on its jurisprudence on temporal jurisdiction and held that because the violation is of a continuing nature, that even though Tunisia had not made its declaration, that after it made its declaration, the court assumed jurisdiction over the issue. And that I thought was because of the intention of the court. Now, as part of my research, I interviewed one of the individuals in the registry of the court. And he shared with me the fact that initially the attitude of the court was to deny admissibility for this case. But there was a change of reasoning because of the weighty issues that were raised in the case. And they decided, in his words, to save the case on the grounds of admissibility and to find the strongest decisions, the strongest arguments for the admissibility of the case. And you would find this as well in the separate opinion of Justice Chikaya, where he said that there were two options open to the court. One, to determine the case on the merit, but two, to throw it out, and that he was excited that the court decided to determine the case on the merits. Now, one of the most important landmark aspect of this case is the fact that the decision recognizes for the first time internationally the right to self-determination as jus cogens or a preemptory norm of international law. I have this slide. Okay, this is where it says this, but I wanted to show you this slide and to show you the two segments of the slide. The highlighted segment was where the court said that it observes. And by using the word observe, it seemed to suggest that it was looking to some other standard and then affirming that standard. But you notice in the first segment, which is highlighted, that there's no reference to any source. However, in the second segment, there's a reference to a source, and the source referenced in the second segment, as you can see here, starts from the Chagos case, the Barcelona traction case, and the like. But by not referencing any source at this point, and by looking at the norm evolution of the right to self-determination, you would find that the African court was indeed the first court globally to hold that the right to self-determination is jus cogens. In 2015, the ILC started its work on jus cogens and appointed a special rapporteur. This decision was issued in September of 2022. By July of 2022, the ILC finished this work and added the right to self-determination as part of the list of issues that fall under jus cogens. So between July and September, if we can't find any other court's decision that said that the right to self-determination was jus cogens, then we are firmly on the fact that the African court was the first court to make that determination. And if that's not landmark, I wonder what would be. I have 1 minute. So there are other landmark aspects of the case that I would have liked to determine, especially the fact that it clarified positive and the negative obligations that arise from Article 20 sub 3. And with that in mind, I'd like to share one of the most important paragraphs of this decision, and which is paragraph 2323, which says, in this regard, the court observes that the notion of self-determination has strong resonance with Africa and carries a special and deep meaning to the people. Colonization, apartheid, military occupation, and various forms of foreign oppression that the continent experienced has defined the African identity and history. And with that in mind, I wanted to speak a bit to a concept that I think embodies this decision, especially with what the court ultimately said about the responsibility of all African states. We all know Ubuntu, but I'd like to introduce you to another concept called Nwanne. And this is gotten from an Igbo expression and philosophy that says Onyahala Nwanne, which means no one should leave their sibling behind. And that's exactly what the court was saying. And Nwanne, the concept of Nwanne, it refers to siblings literally, but in its usage, it refers to community. It refers to everyone. It refers to our shared humanity. And this picture of the Igbo landing, and I'll wrap up now, which we all know from 1803, was the picture of Igbo slaves who were bought in Nigeria and they were taken by boat all the way to the United States. But at some point, they took over the ship, killed the captains, but did not try to save themselves. Instead of living as slaves, they walked into the ocean and died in there. It was said that they held hands, as you can see here, holding each other and walking into the ocean, and yet they died singing freedom songs as opposed to living as slaves. I want you to hold the hand of someone beside you, maybe, and just turn to them and say, I will not leave you behind. No, do that. Just say, I will not leave you behind. And as you do that, I want you to say these words with me. Just say, Nwanne. Say it again, Nwanne. One more time, Nwanne. Thank you.
Thank you very much. That was very interesting. So now it's it's time for questions. How many minutes do we have? About 30 minutes. Okay. So we'll have about 25 minutes of questions. We'll take the first 4. Okay. I see hands. Then I have a third one.
Hi. Okay. Thank you so much for the wonderful presentations. So my first question is to the presentation on the freedom of expression. I didn't, maybe because of the time, but I would really like you to elaborate on how that decision will actually add some flavor to citizen broadcasting, quote and unquote, in the sense that, so in my mind, I was asking that I don't know whether in your paper you try to trace the origin, the reason why there was need for licensing, for traditional media at the time. And now things have actually changed because we see some people, doing what traditional broadcasting would do, but on the internet. And I don't think is every country that they require the licensing thing. So is the licensing thing, I don't know the rationale behind it. And is it still kind of applicable in today's world, especially in the context of that digitization of broadcasting, where even people that are not trained journalists are also part of that ecosystem? That's my first question. Then my second question is to the the one on self-determination. Thank you so much for bringing this issue to the fore. So I'm thinking, because when I read the decision of the court in Nigeria against Nnamdi Kanu, there was an element of the issue of self-determination, and disappointedly, the court did not really, and I know that this decision came, that the court decided that decision after this one. So I don't know, maybe is a thing also maybe in your paper to also, since you've already brought the issue of the Igbos in it, I think that there may be need to critique the decision of Nigeria against Nnamdi Kanu, the aspect of the right to self-determination in view of the decision of the African Court and the jurisprudence on self-determination as we speak. Thank you.
Thank you. There was a hand. Okay.
Thank you very much. My name is Rudy. I'm from Cameroon. So the issue of self-determination is also something that is I'm really interested in, and I'm really happy and grateful for the presentation that was done on self-determination. So I have, and you must not have an answer to this for me, but I have two parts of this question. The first thing regards addressing the issue of self-determination at the Commission, at the African Commission, because most of those cases on self-determination have come to the Commission over the years as opposed to the court. And this, I'll make reference to Cameroon, because two cases have come. The first came in 2003, was decided in 2009, where the commission addressed it right onto its merits. And the second case came in 2017. It still concerned the issue of self-determination for Anglophone Cameroon. And the commission in that case decided that they could not proceed beyond admissibility. So it was decided to be inadmissible because they raised the issue of self-determination. And this particular case, which came in 2017, was decided around 2022, but I'm not sure if this case has been published. Now, I know that the Sahrawi case, and thank you for sharing this case because I've not particularly read it. I know that this case, as you said, was decided in 2022.
Question.
So, yes, so okay. So I know that there's less likelihood that this case was, the commission's reasoning was addressed from the 2022 case that it addressed. So I want to just ask that, did the court make any reference to the commission's reasoning in the 2003 case? That's the first case that it addressed. And secondly, do you think that there is a way that the reasoning of the court regarding self-determination can inform the commission's own reasoning subsequently on the issue of self-determination? Because so far, it seems that they have been very evasive when it comes to self-determination. Thank you.
Good morning. My name is Razan Ali. Thank you to the presenters for the presentations. My question is regarding the West Sahara case. So the UN Security Council in 2025 regards the conflict as a dispute between Morocco and the Polisario Front, and recommends that it should be solved with negotiation, assuming that the West Sahara region is part of Morocco, unlike the decision by the African Court, which actually recognizes it as a settled fact that this is an occupation. So I know there is no hierarchy between the two institutions, but isn't that like confusing? So my question is that, what's the way forward when these two different institutions adopt conflicting positions? Thank you.
Thank you. We're going to stop here. We'll take the second round if there is time. But there's one question for Mary Ann that comes online. It asks, could you comment on the current status of the implementation of the court's judgment in Mali? Do you think this offers any lessons for ensuring that African court judgments translate into meaningful legal and social change? Did you get that, Marianne?
Yes, I did.
Thanks. I'm gonna start with you because we don't have many questions. And then
Okay, thank you very much for, I think those were like 2 or 3 questions, if I'm not mistaken. I think the first part of the question was if this case is still relevant in as much as it was decided in 2019. Yes, it is. It remains a relevant case, especially for future cases that may be filed before the African Commission as well as other African human rights bodies. And in my paper, in the presentation, there was need to examine the 2-tier issue, especially the fact that states shouldn't use this as a weapon. In as much as you need to respect the rules and regulations of states in creating your radio or television station, it's important that states do not use this for political reasons, because that's one of the reasons why a major reason why the radio station was shut down. And it's also relevant even to the digital space, to digital communication, our non-conventional communication nowadays. In as much as we have many people, trending into online journalism, etc., they need to ensure that they respect the rule and regulations of states. And in the same line, the states shouldn't use, this as a weapon in clamping down on these operations. So that's the little bit I have with respect to that. I hope I addressed the issue.
you have many questions. I guess when it comes to self-determination, questions arise. So over to you, Ikechu.
Thank you so much. And thank you so much for all the questions. I would try to address as much as I can here. And I'm sure we would have time after, over lunch to also talk some more about this. Thank you, Tosin, for your question. I think this addresses most of the questions. In the evolution of the right to self-determination, and especially in the context of in the African context, especially in the transition from colonial to the post-colonial era, if you want to call it that, there's been a distinction, and this is established also as well in international law, between internal self-determination and external self-determination. And so when there is a part of an established state with territory that seeks to secede from the state, it's assumed to be, or it's referred to as internal self-determination. And for internal self-determination, the current position of international law is the principle that a territory that already exists and is homogeneous, quote unquote, should not be broken apart. And especially in the context of Africa, after independence, there was some form of an understanding within the OAU, and that extended within the African Union as well, of the principle that you don't interfere in a state that is already, whose boundaries are already set. And so the cases that went to the African Commission were all dealt with internal self-determination. And that is why the decision of the Commission came out that way, because there was that understanding that self-determination
extended to the peoples keeping their identity as maybe distinct from the national identity, but did not extend to secession. And so that was the position the commission has held, and it sustained it all through. The difference with the Western Sahara case is that it is a case of external self-determination because Morocco is occupying Western Sahara. So it's a bit of a different, it's a different version, a different expression of the right to self-determination. And to the narrow case of Nnamdi Kanu, that also falls largely within internal self-determination. And that is why if the case goes to the African Commission or goes to any of these mechanisms, the likelihood is that you still get that response that internal self-determination it does not extend to cessation. So, but yeah, I'll see if there's a part of my paper that can take that, especially because I invoked my Igbo-ness. And to Rudy's question, I think I've answered this a bit. The decisions from 2023 and 2017, and whether the court's opinion or the court's decision could influence future decisions of the African Commission. If there is, and this is another reason why this case is landmark, because this would be the only case of external self-determination that, at least at the moment, can ever arise in Africa, except one country decides to invade another and occupy them, and then would have another case. But Western Sahara is the last colony of Africa. And so, as of today, that's the only circumstance where external self-determination can arise in Africa. So if in the future, and I hope not, there's a case of external self-determination, I would expect that the opinion of the court or the decision of the court will influence the decision of the commission. However, I note with disappointment the fact that within the African Union's engagement or participation in the advisory opinion of the International Court of Justice on Palestine in 2024, the African Union made a submission, and many African states made submissions, but they never referenced this case from the court. And I thought that was a missed opportunity to assert our Afrocentric jurisprudence. It was I noted it with great disappointment, and so I feel and there had been, of course, the ICJ did not reference the case as well, and I think that was because maybe we did not put it up. The other question is on the UN Security Council 2025. I'm not familiar with that resolution because the UN has historically maintained the fact that Morocco has no historical ties with over the territory of Western Sahara. However, the United States, who is the pen holder in the Security Council on Western Sahara, on the situation in Western Sahara, has recognized Morocco's claim over Western Sahara. And a few other countries have followed the United States in the aftermath of this decision. And we know how, state recognition works. And so indeed, it's leaning a lot more towards recognizing Morocco's claim than the other way, as the court suggested. But the US, under the first Trump administration, made that recognition. Under the Biden administration, they decided not to touch it at all. And under this second Trump administration, they've sustained it. If you remember, the first act of the Kenyan president, William Ruto, when he was elected, was to recognize Morocco's claim over Western Sahara through a tweet that was immediately deleted, and they stepped back from it. So there's some hesitance, but whether it's in Africa or in Europe, a lot of countries are tilting towards recognizing Morocco's rule. And if that continues in that light, it may well crystallize as state recognition. The final one was what the way forward is. Yeah, I believe that the African Union needs to step up and take responsibility. The African Union has been docile. The African Union has indeed, as far as I'm concerned, been complicit in this. And they have to do something about it. Because as you all know, Morocco is the only country that has not ratified the African Charter. And another reason why this is a landmark decision is that the court expanded the impact, the impact or the reach of his decision to cover Morocco, because it says all AU member states. So that is another reason why this decision is landmark as well. Thank you.
Thank you so much, Mary Ann.
Okay. Thank you, Brenda, for the question you asked. So after the judgment was passed by the African courts, a public dialogue was held in Mali. And this was to assess the implementation of the court's decision and to develop strategies for full compliance. But as of now, based on the information that we have online, the law remains unchanged. The family code has not been amended to reflect the provisions of the judgment. So yes, this case offers some lessons for ensuring that the judgment of the African court translates into meaningful legal and social change, as it indicates a need for continued engagement and action to address the issues raised by the court. This is where we all come in. It's not something we have to leave for just the civil society organizations in Mali. As African states, we all can mount pressure on the government of Mali to ensure that the judgment of the African court is actually implemented and is seen working in Mali, as this will also ensure that other states toe the same line to amend their laws and abolish all forms of discriminatory practices that violate the rights of girls. Thank you.
Thank you so much. Just two pressing questions, very brief, no abstract or preamble.
Thank you for the one. I have just a question about the last landmark. You don't think? Do you think that this case is more an individual case or a masked interstate case, according to what you already said, and the intervention of the Sahrawi in this case, which was so relevant rather than the claim of Bernamona in this case? Thank you.
There's a hand there.
Hello, everyone. My question also is about the self-determination part. It's also close, at the risk of being repetitive, it's close to discard question as well. How can we realize Ubuntu, like the last part of the presentation, on an actual legal level? Because in the same case of Mundra versus Benin, like when there was a case and they issued a claim against all the states that voted against, that actually voted for the inclusion of Morocco again with the African Union, the whole principle was rejected as well, and they found no violation. So like, how would we add this extra legal layer to Ubuntu to hold those states actually accountable within all of the legal implications of that principle?
Thanks. And then I saw one last one, Dr. Dube. Doctor.
Thank you, Chair. The commentary, if that's okay. Oh, I wasn't audible. Okay, can I start again? Thank you, Chair. So I'm going to ask a question to the Igbo men, but I see that we have received quite a lot. So I'm just going to make a short comment with your permission, Chair. So I researched on South Africa, which is a jurisdiction that is very known for innovative judiciary, where whatever the court says, it goes, even being declared without legal authority. So when it comes to your presentation, I've just collected my thoughts here, and I do think that the African Court's recognition of self-determination as jus cogens is actually attractive, but I believe that it is doctrinally incomplete. And why? Because the court did not clearly distinguish between the erga omnes character of self-determination and its alleged peremptory status. So to me, that is a problem because the court also did not apply the methodology for identifying use cogents, and namely demonstrating that the norm is of general international law and that it is accepted and that it is recognized by the international community of states. So that is a challenge because the court seems to have treated the moral and historical importance of self-determination as sufficient to establish the peremptory status. But that then weakens its persuasiveness because the court did not, because courts generally do not create use cogents by declaration. They have to identify it through evidence. So just to conclude, I will say that the conclusion in paragraph 298 is very attractive and is very defensible, especially after the Palestine 2024 advisory opinion. But it still remains weak because it has not been justified with authority. Thank you.
Thank you, Mr. Ikpome.
Thank you so much. You didn't tell them. Anyway, I'll start with my sister right there that talked about Ubuntu, but I want you to also say one name because that's actually where I was going. But I agree with you, and I think that what the court's decision was is the fact, and I think that answers the question also from here, is the fact that the responsibility does not just extend to states as, you know, as component parts of an international system, as well as much, it doesn't just extend to them, but also extends to individuals. And they made that allusion in asserting the personal jurisdiction in this case, because almost all the states had raised an objection to the fact that this individual is Ghanaian. He, of course, has no personal injury. And of course, the court said there was no need for, you know, personal injury for local standing and the like, but went forward to state that the issues raised in the case were so important that every African citizen should have a vested interest. I'll try to find the paragraph and I'll share that with you. And so the court, in a sense, attempted to go beyond or to lift the veil of states to even identify individuals. And in this case, making a good example of Bernard Mona, who had filed this case, as a step he had taken to support the self-determination of the Sahrawis. And so we definitely need states, we need people in power to take steps towards supporting what the self-determination of Western Sahara, because we know how the international system works. Like I said, the state recognition is going in the opposite direction. And we don't have many states, maybe except states like South Africa and Namibia and a few other states that voted against Morocco's admission. Maybe those are the states that still stand in support of Western Sahara, but it's going more and more in the other direction. And we just need people to take responsibility. We need the African Union to take a strong stand. The Sahrawi Arab Republic is a member state of the African Union. But the African Union claims, even in some of the decisions, some of the pleadings filed, that the AU has ceded the case of Western Sahara to the United Nations. And I think that is scandalous. And to Dr. Dube's point, I agree with you. And I think that is exactly the point we make in the paper. The fact that the steps were not followed, it was a declaration, and that definitely more needs to be done. However, we notice that in the Palestine advisory opinion, the court also makes a declaration, but it seems like it follows the work of the ILC, which attempted to find state practice and to find opinion reviews and to find oh, sorry. Okay, I'm being harassed. But I'm happy to take that conversation forward, Dr. Dube. Excited to take that forward. And forgive me if I didn't take your question. You know who to catch. She's here. But thank you so much.
Thank you so much. I'm going to give each of you 1 minute to just wrap up. I'll start online. Solomon, they haven't asked you any questions. So 1 minute, a key takeaway from your presentation, please. Oh, you can also start by answering your question online. We can't hear you.
Okay,
Okay.
Okay, thank you very much. Takeaway, I think that as I had indicated, I think that the court's approach to the case, I'm referring to the Commission on Human Rights and Good Governance, the United Republic of Tanzania, represents a very progressive and expansive interpretation of the rights regime, in the sense that I'll just read one line, which I talked about. I said that the court made intra-group phenotype-based vulnerability actionable within law, showing that harm can arise from visible genetic difference within the same racial community, not just traditional categories like race or ethnicity. Thank you.
Do you want to answer the question online? Can you see it?
Oh, okay. So let me see whether... no, I've not seen the question yet.
Okay, we'll read it for you.
Okay, so what work is done with AU member states to ensure that they apply to resolutions of the AU?
Got it?
What work is done with AU member states to ensure that they apply the resolutions of the AU states protecting people living with albinism? Of course, within the context of the case, as I said, the court had put in place several remedies, several transformative remedies. For example, Tanzania was required to put in place a compensation fund. There's a reporting mechanism where Tanzania is supposed to report from time to time. Steps is taken to protect persons living with albinism and so on and so forth. At the AU level, I must say that I am yet to I'm yet to establish beyond the court's own remedies what the AU has done. Of course, there is a broad action plan at the AU level, some of which relate to state obligation to protect the right to life and so on and so forth. But specific work done with AU member states, I am yet to take my reading there. I think that is something worth exploring. But of course, in the context of the judgment, as I have said, the court has specifically ordered some transformative remedies, including specific duties for Tanzania to report what actions it is taking to reform its laws and to adopt effective strategies more broadly for the protection of persons living with albinism. This is something that is worth exploring to find out what specific steps and mechanism is being taken at the AU level to protect persons living with albinism, because of course the problem goes beyond Tanzania. Thank you very much.
Thank you so much. Mary Ann, 1 minute, brief.
Thank you, Zozo. Okay. So from the paper, we can see that girls are vulnerable and their vulnerability is heightened by cultural norms and religious practices in various African countries. And if we don't join forces to ensure that child marriage becomes a thing of the past, through legal protection and laws that meet international standards, more girls will become victims of child marriage. Sexual violence will increase, and more girls will die from childbirth complications, thereby jeopardizing the chances of meeting SDG 3 and 5 by 2030. So call on everyone to use your various platforms and networks to ensure that the decision of the court in the case of Mali becomes a reality. Thank you.
Thank you. Then Chofo Chair and then followed by Ikechukwu.
Okay, thank you. The takeaway, scholarly analysis of landmark judgments in international human rights law have identified several recurring markers of exceptional judicial significance. Our own very learned Professor Vinyun here, influential taxonomy identifies 4 indicators: doctrinal innovation or consolidation, judicialization of pre-existing norms, influence on subsequent practice, and relevance to continuing socio-political conditions. And the broader literature on norms, entrepreneurship in international adjudication confirms that decisions acquire landmark status not merely by stating the law, but by making it actionable in a specific regulatory context for the first time. Thank you very much.
Thanks. I think I may have missed the question about whether it was a veiled interstate case. And I think that's also one other reason why that case is landmark, because the court attempted to pull in as many states as possible. One part of the court's process that you don't find elsewhere is that once the court gets a case, it actually sends it to all the member states. And so it attempted in this case to pull in as many member states as possible. And I think it was because of the weightiness of the issue. So there's a sense in, I think you put it right. It seems like a veiled interstate case in a sense, because the Sahrawis, we are advancing arguments against Morocco, even though Morocco was not a member state, a named party in the case. But for a takeaway, I think that we see here that the people we have in these mechanisms, in these courts, in these commissions, determine what cases, how the cases come out, and determine the impact of the cases. So I'd like to put a plug for the work we are doing at the Arusha Initiative, and want to invite all of you to be part of the Arusha Initiative to make sure that we have the best judges, commissioners, and experts at the committee. Thank you.
Thank you very much. I'm sure we are all awake now after your nice dinner last night. So I'm not going to stand between you and your tea. Thank you very much. Let's give all of our presenters a round of applause. Thank you, Francis. It's tea time. Huh? Until when? Until 1:15.
Hey, brother. Yes, I received them last time. Thank you so much.
Couldn't hear. Oh, sorry. Yes, Kehinde. Tola Kehinde, can you hear us?
Yes, I think he can hear you. Good day. Good day.
Yes, we can.
Oh, okay.
Yeah. Tola Kende is my co-author, and I believe he's online. He can equally hear you loud and clear.
Okay. Do you guys have a PowerPoint? Have you sent the PowerPoint?
Yes, we have a PowerPoint.
Did you send it to?
Can they try to share it?
Oh, okay, share it. Try
Okay, I
sharing.
can share. Okay, can I go ahead and share?
Yeah, please do. Since you guys are.
Okay, no problem.
Yes. Oh, fantastic. Yes, yes, good morning. It's still morning. Welcome to the second session of today. We have three speakers, or three papers to be presented. I think the first, okay, you've shared. Can you put it in presentation mode? Tola Kehinde and Kelechi Igwe.
Yeah.
So each of the presenters have 15 minutes. And would have, after the presentation, we'll have about 25 minutes for answers and questions and answers, right? Then after that, then we'll have a minute each. Please, let's try to, the good thing is that one of the, we only have three papers presented here, so at least we'll have a little bit of time, but we're trying to not stand between you guys and lunch. So we'll try to finish by 20, yeah, by when do we finish this session? Because lunch is 12:15. 12:45. Okay, we can finish at 12:45. So thank you. Kehinde and Tola Kehinde and Kelechi Igwe, please, the floor is yours for 15 minutes. Thank you.
Okay. Once again, we are very grateful for the organizers of this conference for accepting our research paper. So I'll go very straight to the topic. Our topic says Beyond Vestigial Colonialism, Rewriting the African Courts Ogenk Judgments Through the Jurisprudence of Communal Stewardship and Ancestral Pedigree. My chief co-author, Tola Kehinde Benjamin from Redeemers University, and my humble self, I'm Igwe Kelechi from the Nigerian Institute of International Affairs here in Nigeria. So I'll go straight to my slide. I've read out our topic. I don't know why the slide is refusing to go to the next slide. Sorry, let me try and go to my next slide to see if I can. It's quite difficult here. Can I stop sharing? So let me know what's wrong with my computer to know if it is hanging or.
Yes, yeah, maybe you can stop sharing and yeah.
Okay. Yeah. Okay. Let me go over it again. Okay, so back to it. We try to investigate some important judgments from the African courts to understand how African court judgment have equally affected communal areas within Africa. The African court has generated an expanding corpus of human rights case law over the past 20 years. Despite this steady quantitative growth, this regional judgment remains largely invisible and unsighted within the domestic legal system and judiciaries of member states. This lack of domestic engagement stems from deep-seated disconnects. Continental jurisprudence remains conceptually tied to Western legal methodologies that fail to resonate with the lived experiences of African society. This paper equally addresses these invisibilities by executing formal critical rewriting of the famous Ogenk case. And we'll try to understand, give a contextual analysis of the Ogeng case. Of course, Africa has witnessed many kinds of communal cases like this, but with little or no documentation, and equally lack of, bringing these legal cases to the fora, to academics, to the think tank for Africa to document its jurisprudence and cases. The Ogen case involves a forest dwelling indigenous community that faced systemic and state-sponsored forced eviction from their ancestral home in the Mao Forest by the Kenyan government. In its 2017 merit judgment, the African Court took a monumental step by formally recognizing the Ogeng as an indigenous population whose ancestral land ties are land ties are protected under the African Charter. However, a close examination of the court legal reasoning reveals that the decision remained structurally trapped within the individualistic Eurocentric legal framework, meaning that the court proceedings and the court legal reasoning only review the methodologies used in the Eurocentric legal framework by treating the right to property under Article 14 and cultural rights under Article 17 as separate legal categories. The court failed to capture the holistic reality of indigenous identity. And the original judgment fragmented the integrated life of the Ogeng by slicing their experience into separate legal compartments, treating land, culture, and resources as detached silos, and we shouldn't have been. Land, cultural ties, and resources the compartments are always a big deal in Africa, but you see the courts trying to separate these, items as silos, detaching them, making the judgment against the Ogeng a much more a difficult one. But the African court relied heavily on European and inter-American precedents, which imported an extraction-oriented capitalist bias that views land primarily as a static commercial asset. The Eurocentric flaws of the original merit, in this case, makes it difficult for the Ogeng to receive a favorable judgment based on the African context, and that's the bedrock of our research. Now, by defining property in terms of measurable economic value and formal land certificates, the court failed to legally recognize that for the Ogeng, land is an extension of kingship and ancestral pedigree. The conceptual failure left the judgment vulnerable to domestic resistance, allowing the Kenyan state to treat the ruling as a standard bureaucratic boundary dispute rather than a structural justice. In 2022 reparation phase, the African court defaulted to the standard Western legal reflex by awarding monetary compensation to cure multi-generational displacement. The court awarded the Ogeng 57 million Kenyan shillings for material, prejudice, and 100 million shillings for moral prejudice, translating a profound existential fracture into financial transaction. By reducing ancestral heritage to quantifiable cash sum, the court, unwittingly reinforced the colonial logic that indigenous livelihood can be brought, sold, or paid off by state fund, which we are used in the colonial era. In the colonial era, we are used to the colonial masters, paying off communities that have land ties or heritage. And we are used to, colonial settlement, and it's very much famous in Kenya, where the colonial interests are on particular land, and they'll pay off. Sometimes they'll not even pay off the indigenous ancestral owners of that land, but due to the superiority of the European firearms, they impose their authority on the local ancestral landowners without any authorization, and these cases, linger for many years, for centuries, for passed down to generations. Zimbabwe is a classical case. We can revisit, the Zimbabwean colonial experiences to extract, many more legal cases like this. But today we are focusing on the Ogeng from Kenya. So I'm trying to make us understand that the case of Ogeng is equally and a kind of experience within Africa, not just the Kenyan issue, but Zimbabwe, like I mentioned. Equally in Nigeria too, we have similar cases in Nigeria where colonial occupation and expansion affected natural settlement. Our rewritten judgment consciously breaks away from the inherited colonial jurisprudence by merging property rights and cultural identity into a single invisible legal matrix, using the foundational Pan-African principle of Ubuntu. The shadow judgment rules that the state forced eviction did not merely violate an economic interest, but severe the social order that sustained the community in terms of legal judgment this time around. The rewritten text replaced the Western model of individual ownership with the African model of collective custodianship, viewing land as a sacred trust held concurrently by the living, the dead, and the unborn, and which is the normal African cosmological belief. Deconstruct the state's environmental pretext, establishing that the forest dwelling community and the forest ecosystem are ecologically and legally co-independent. The shadow judgment completely rejects financial compensation as a remedy for historical displacement, focusing instead on spiritual restitution and institutional reconstruction. The respondent state is ordered to immediately halt all eviction processes and formally recognize the Ogeng community as a perpetual collective custodian of the Mau forest in Kenya. The degree mandates the creation of a co-management framework that vests primary regulatory and resource authority over the forest directly within the traditional customary institution of the Ogeng. Furthermore, the state funds are redirected away from the individual cash payout into an ancestral heritage restorative trust managed by the community to rebuild their traditional governance and restore sacred burial sites. And these kinds of issues are not easily reconcilable, but the colonial damage and the colonial justice system have done severe harm to the African ancestral ways of life. The critical, in conclusion, and this time around, we are looking at the implication for decolonizing African Union law. We are saying that the critical rewriting executed in this paper demonstrates that the persistent domestic invisibility of African Union legal decision is fundamentally an epistemic crisis. When regional human rights bodies speak exclusively in the borrowed language of the Western legal individualism, they alienate the domestic judiciaries and local constituencies needed for enforcement. Decolonizing the law by elevating indigenous framework to primary sources of treaty interpretation is the definitive pathway to establishing the local legitimacy and authority of the African courts. Ultimately, grounding the regional adjudication in authentic continental tradition ensures the decisions are no longer seen as external imposition, but as organic expression of justice. Thank you for having our time and listening to our brief presentation.
Thank you very much. Thank you. The next presentation is by Nomkosi Zulu. Yes. So I hope you'll be able to beat the record.
Good morning, everybody. Hi, my name is Nobukosi Zulu, and I'm a law and policy specialist, and I work in the early childhood development space. And I'm very excited to be here today to talk about, fancy clicker thing, to talk about the case in the rewritten feminist judgment. And I'm talking about early childhood development. That's the vantage point that I'm presenting today. And I'm looking at the Tanzania case, the Tanzania schoolgirls case, which I'm excited about. So I'm not going to get into the facts. We received some of the facts yesterday. And if you don't know, there was a case where school children were being denied access to return to school if they got pregnant or they got married. And they were subjected to some very inhumane treatment in the way in which they were being forced into pregnancy tests, detention, and of course, being expelled from school if they were found to be pregnant and then denied re-entry even after they gave birth to the children. And the committee rightly found that there was a number of violations of the article, all those 1, 3, 4, 10, 11, 14, 16, and 21. And it gave some remedies that the testing had to be prohibited and that there was some regulation reform that was needed for the country to be compliant, and that the school girls had to be readmitted, and that the government had to provide sexual reproductive health education. But that's not what I'm here to talk about today, because I'm using an ECD lens. And what the committee saw was a schoolgirl. It did not see the first developmental environment of the child that the girl was going to have. So for the child that the girl carried and the child that she gave birth to, the expulsion from the school was not merely an educational deprivation, but it actually altered the conditions in which the child was born into the circumstances. And those were shaped by state policy. And that child doesn't appear anywhere in the decision. And at the heart of the heart of the paper is that the committee only saw the schoolgirl who was there, and it completely ignored her child. And so the first problem is that there's this invisible child. And what the committee missed was the first 1,000 days of a child. In ECD, we talk about the first 1,000 days, which is where there's this incredible growth process from conception to 2 years, of which the child experiences intense maturation, and the brain, health, all their cognitive functions happen in the first 1,000 days of the child. And there's a nurturing care framework, which also considers the health, nutrition, security, responsive caregiving, and early learning opportunities that a child needs in those first 1,000 days that actually set them up for the rest of their life. And the obligation to prevent nutritional deficits on the child that happen in the first 1,000 days, either before the child is born, as it happens with the mother, the treatment of the pregnant mother, as well as after the child is born, the environment in which that child is placed in. And so the legal gap that was there is that the committee didn't consider all the children that were involved in the case. It didn't consider every child's right to survival, protection, and development. And it's already there in the CRC general comment that young children are rights holders from the moment at which they are born, and the state must actively protect the conditions of their development. And this didn't happen. And the committee had these facts before them. They just chose not to see them. And then the second problem was the remedy, was that the readmission order, it gave rights without conditions. And something that we've been hearing repeatedly here is that the incredible rights orders are given, but they actually carry no teeth with them. They are not complied with because the conditions in which these rights are made are not conducive to making sure that the judgment is done. So readmission, standing alone, it required that the mother return to school without the state providing any conditions that would make that return consistent with the care obligations that she has towards her infant child. She was effectively being asked to choose between going back to school or providing early childhood development care for her child. And so the remedy ordered correctly that the girls had to be readmitted, that they needed support for the lost years, and that sexual education needed to be a part of the state's obligations towards the girls. But it didn't talk about any named obligation that the government has to provide care, and the entire care relationship that the girl has with the child that is a limiting condition for her to return to school was completely ignored. And so and that is what this rewrite is looking at. Because at the end of it, if the remedy does not resolve the choice, it's not actually a remedy if it just makes it more complicated. And so the state transferred its obligations back to the child that it had violated in the first place. And the question that is asked then is, does the state have a legal obligation to provide care? And I argue that actually it does have a legal obligation. And these are the articles. I'm not even sure how much time I have. I've got good time. Okay. The state does have obligation to provide care. CRC Article 18(2) and 3, it states that the state, it has to ensure that the development of institutions, facilities, and services for the care of children, which can easily be read to understand that the state has an obligation to provide child care services for children. Article 5, read with Article 14, is that the survival and development of a child cannot be discharged without the caregiving infrastructure that is necessary in the early childhood development years of a child. And it expressly obligates the state to provide the appropriate healthcare for the expectant and nursing mothers, and that it explicitly names that mother-infant care relationship as a direct state duty, which this judgment didn't really look at when you say the girls go back to school without considering this relationship. And already in Tanzania before, and in Rwanda and in Botswana, there's been an express statement that the state is required to provide childcare facilities so that adolescent mothers can return to school. It's not aspirational, it's what's already required of states. And the advisory opinion state that the right to provide care, it mustn't be frustrated by state policies that impose care burdens while withdrawing the support. The state has an obligation to build the type of public care systems, which include childcare centers and community support services, that would ultimately allow for the girls to be able to go back to school and complete their education in a meaningful way. And so the respondent states in this, and the third problem is that the schooling framework of it is that this big word that I learned, mother normativity, I like it. And the school-centered conception and the schooling-centered conception of development is that the state required that the expulsion policy, it was a legal enforcement of this mother normativity in its most coercive form. It required the girls to either be a student or a mother, and it didn't create the conditions that allowed for it to be a student who is a mother through providing care. And the committee's Article 11 analysis, it was correct that there was the harm, children were excluded from school, so they need to go back to school, which makes sense. And that the girls who became pregnant or had children, that they needed to have an opportunity to continue their education, that again is the right of the girl. But then the survival and development conditions under Article 5 are the rights of every child. And those two provisions read together, they require that the state had to ensure that the conditions of the child going back to school didn't require her to choose again between her educational aspirations and her responsibilities as a mother. And then the Constitutional Court in South Africa touched on this in the Hugo case, where it treated care as a natural attribute of women as well, as not something that the state should enable and support, which is sort of what this case just made the assumption. It didn't consider what is the role of the state in providing childcare services to mothers. And so the approach that the rewriting took, I used an ECD framework, Ubuntu, relational ethics, and African feminist jurisprudence. And the new findings of the rewritten judgment is that is a violation of Article 11 and 5, is that the expulsion, it didn't only violate the girl's right to education, but the state's developmental obligations to the child that was born to her. And it also, then Article 4 was that the best interest can be applied twice. It can be applied simultaneously to the girl who's expelled and the child that is born during the expulsion time, and that the best interests during those 1,000 days require the state not to generate the conditions of their development that disadvantage through a harmful policy that is directed at the mother. And Article 4, the relational lens reading it, is that the best interest principle must be understood relationally and not individualistically. That Ubuntu tells us that the mother has a relationship with the infant child, and that relationship needs to be protected in whatever remedy that the court gives, that the committee gives. And looking at deponent 2, who was part of the case, is that the state passed on the problem to the person that to the way it had created the problem. So it expelled the girl who was only in Form 2. She became a mother because of the conditions the state had created in failing to do any sort of comprehensive sex education for her. And then the state transferred the cost of its own policy failures entirely onto her, as she's now a mother and the child. You expel her, then you tell her she can go back to school, but you don't give her the environment that she needs for her to be able to thrive. So the rewritten remedy, the orders are that the state must provide and fund infant and toddler care, and that it's an obligation that the state has, and that the state must identify and find community-based care work, care opportunities for the children, and that it must implement flexible scheduling for the nursing mothers to return to school so that they actually can go back to school. And it must report on the development conditions of children born to the expelled girls, not just the re-enrollment numbers. And the legal basis, I've already discussed this, I'm not going to repeat it again. And what does this paper add to the scholarship? It introduces an ECD science as a primary analytical framework, which is not something that is commonly found. It considers the child who is born, that the literature on girls' rights is not engaged with the developmental interests of the child during the school-going age, because we see that from what I've found online and what happened in Tanzania is the girls still don't go back to school because the environment, they are now mothers now, and you can't ignore that in the type of judgments that you give, and the being specific with the type of institutions that what the state should do, name the mechanism, childcare services, access to early childhood development centers and things like that. And that it's a question that the committee can ask itself about what happens on a Monday morning once this decision goes forward. And it's a rights compliance issue. It's not just about policy activism. The end.
Thank you. We seem to be doing very well here. Lasan, the floor is yours. Please try to beat the record.
Morning, everyone. Prof, I'll make sure that I'll try to beat the time, but I'm not sure. Yes, I'm presenting this paper as co-author with Dr. Dorcas, and I would like to thank the organizer for accepting our abstract and also giving us the opportunity to talk about, let's say, pressing issues within the international law. And one of the contemporary debate still ongoing within international law, within the international affairs, is the issues of corporate accountability. And one of an American economist, famous one, Milton Friedman, theory said that the main obligations for a corporate entity is to pay the salaries of its workers, pay taxes, and make profit. And the case we are reviewing this morning will show us that if we stick that corporate obligation is to make profit, pay the salaries or the taxes, it can lead us to disastrous consequences for local communities. And our case paper is titled Beyond State Centrism, Reimagining Corporate Accountability in Ligue Ivoirienne de Droits de l'Homme and Others versus Côte d'Ivoire. The fact in the fact in few minutes. In August 2006, a vessel company, Probocola, produced a toxic petrochemical slop at the sea in Abidjan. It was about 500 tons of toxic waste that was dumped in Abidjan Laguna. And are in almost 18 sites across Abidjan. It's led to more than, let's say, 15 deaths with 100,000 emergency situation in Abidjan in that time. For Probocola to dump its waste in Abidjan, it was not, it was, as I've highlighted previously, motivated by economic choice. They've decided they have an opportunity to treat the waste in Amsterdam in the Netherlands, but they have chosen not to do so because of economic reasons. Because doing it in the Netherlands will cost them 500, more than 500 euros, 1,000 euros. While in Abidjan, they had the opportunity to create a newly company, and with the amount of 17,000, they were granted the opportunity to dump the waste in Abidjan. And then it's lead to the consequences I highlighted. And the Ligue Ivoirienne, the Droits de l'Homme and other organizations filed the case before the court in 2016. And the court in 2023 released the judgment and held that Côte d'Ivoire has violated various rights of the Charter, Article 4 for the right to life, Article 16, and for the right to satisfactory environment, Article 24. And then the court situated the breach of these obligations within the state positive obligations on due diligence. And our finding is that the court immunized the corporations because the court limited its jurisdictions only on Côte d'Ivoire. And then in the court finding, the liability was confined to state-centric paradigm that and Trafigura was direct responsibility was never addressed. While the UN guideline principle, the court cited the UN guiding principles in its paragraph 142, highlighting that within the current international law, while the primary responsibility to bear obligations under international law belongs to state, the court recognized that private companies also has obligations to respect human rights, but the court landed there and didn't conclude that the court, the Trafigura has obligations under its jurisdictions. And then it was motivated by our finding that the profit-driven architect of the harm has left those that the rules were supposed to protect that are the victim with impunity or injustices. And then our claim is that the court's silence on the corporations was a choice, an interpretive choice, and not a legal constraint. Making this claim, we are joining the dissent opinion by released by Blaise Chikaya. In his dissent opinion, he highlighted that the state responsibility under international law within this case was not well addressed by the African Court of Human Rights. And then he also accepted that the primary liability in this situation lies with the corporations and not only with the state. And then he put forward the fact that under international law, we have this concept of horizontal application of the rules to private actors. And meaning that in that kind of situation, corporation can be primary bearers of human rights when their activities are harming those rights. And then our methodology, we are using three methodology, three tools. The one is the third world approaches to international law. I'm glad that we have Babatunde here, who is a great scholar when it's come to TWIL. And then using TWIL, we exposes, the paper exposes how the current international law is still based on state-centric and also are contributing to injustices. In fact, TWIL well demonstrated that how the framing of the current international law allows the global north to use Africa as a natural resources reservoir and externalizing non-economic harms to Africa, while the global north is also benefiting from those resource exploitation. And in our rewriting, we use a systemic integration, particularly Article 31 and 3 of the Vienna Convention on the Law of Treaty, which provides for a systemic interpretation of a treaty, meaning that when we are interpreting a treaty, we must take into account the objective and the purpose of the treaty and not only the verbal words of the treaty. Yeah. And we have highlighted few scholars in TWIL. We have James Gaiety and Angie. But interestingly, the TWIL also demonstrates the asymmetry when it's come to the relationship between state and corporations. In general, international investment law treaties has accommodated companies and give them right to be able to hold state accountable before investment tribunals, while the contrary is not possible. Why? When these entities are violating rights. And our writing is also based on a few doctrinal elements. And the fact is to say that the African Charter on Human Rights is enforceable on corporate and provide for corporate duties. Using the interpretation tool of Article 31(3) of the Vienna Convention on the Law of the Treaty, and also the purpose Ziv reading of the Ouagadougou Protocol on the Statute of the Court can lead us to conclude that yes, this is an implicit reading that the court has a room to recognize corporations as duty bearers. And even the court has used this technique of interpretation. When you look at the paragraph 31 to paragraph 38 of the judgment, you found that the court used in responding to Cote d'Ivoire objection that the court does not have a jurisdiction because the applicant was invoking the African Convention on the Conservation of Nature. Cote d'Ivoire argument was like, this is not a human right treaty, and then the court does not have jurisdiction over it. But the court response was like, yet the convention is not framed in human right languages, but still looking at the purpose of the convention, particularly Article 2 of the Article 3 of the Article 2 of the convention, there is a room for the court to consider that it has human right provisions. And then this is the tool we are using, because when you look at the African human rights system, there are huge development of investment instruments that are incorporating human right provisions. One of them is the ECOWAS Supplementary Act of 2008, which provide for cooperation to respect human rights and respect the environment. Yeah, and then also we are using another tool of interpretation, which is the jurisprudence comparative jurisprudence, to say that development before international jurisdictions, before domestic jurisdictions, has highlighted that there is a room to conclude that cooperation has obligations under international human rights laws, and also we can enforce those obligations before national or international courts. Before international court, this is such subject to debate because there are still some scholars that are debating that the special tribunal for the Lebanon is not purely an international jurisdiction, but my opinion is that it's still it's an international jurisdiction. And in the new TVSLA, the Lebanon tribunal concluded, read that the word person and conclude that the word person includes private legal persons, and then held the TV accountable for on the basis of contempt of jurisdictions. And an important case also that we use is the Nefsun versus Hayara before the Supreme Court of Canada. In fact, in this case, the Supreme Court refused to treat corporate immunity from customary law as settled and let the claim proceed. And another important instrument we are also using in our rewriting is the Malabar Protocol of 2014, which provide for corporate criminal liability within the upcoming African Court of Justice and Human Rights, if the African state are keen to ratify the protocol. And also another important element is within the Cuba case, the court also has named corporations and other prosecution of company personnel. And in our rewriting, we also use the fact that a polycentric responsibility, and then say that even though Cote d'Ivoire can still be held accountable for not upholding its due diligence obligations, the responsibility here are shared, and Trafigura has responsibility for the harm he has caused to Cote d'Ivoire. And then the state breach the duty of vigilance that has been provided in SERAC, but the corporations, under its intentional structural choice, executed a corporate policy. It was deliberate because they had a choice to treat the waste in Amsterdam, but they have chosen to treat it in Cote d'Ivoire in order to gain in cost. And and our main argument is that the void of immunity, Cote d'Ivoire has signed an MOU, I didn't highlight it, with the company for its jurisdiction not to hold the company management accountable. For us, it doesn't matter because the right data in question here are human rights. And the remediation, our claim is that there must be a special care for contamination-linked illness. Then our main claim is that Trafigura must contribute to that. And also we are calling for structural reform of for Cote d'Ivoire to domesticate the ECOWAS treaties and all other treaties that has recognized corporate as obligations bearers. And our final word is like accountability was available for corporations, but the court has chosen not to follow that path. And then a purposive 12-informed reading turns the African system toward a polycentric model of accountability. And African human rights jurisprudence can be made responsive to the realities of transnational corporate power. And then the main conclusion is that those who take wealth out of the continent bear responsibility at the highest level for African environment and African lives. Thank you.
Yes, thank you. Thank you to all the presenters. You've all kept to time, maybe except for Lassane. Yeah, you went a minute above time. But we've had very interesting presentations on, looking at reframing the thinking around judgment by African courts, using Pan-African lens and looking at ways of rethinking these ideas. And if any of my students from next semester are here, they must know that critical rewrite would actually be one of the things you guys will have to do next semester. I think I can cite about 2 or 3 already. But yes, at least you guys have some sort of added advantage, right? By listening to this. So we are going to, I think we have, about 25 minutes thereabout for questions and answers. So we'll take 3 at a time. 3 at a time. I know you are the first, yes. Then the gentleman here. I know. Then, of course, yes, fortunate there. Yes. So then, of course, I'll come back to you. I'm not sure how to track the questions online, but please you start with her. Let's start with her. Then the gentleman there, unfortunately, then we'll go to the next round. Yes, I see you. Yes, please let's keep it very short.
Thank you.
And straight to the point. Yeah, thank
Hello,
you.
everyone. My name is Helifat. Great presentation for all the presenters. But my question is directed to, can I call you Dr. Nobu? That's okay? Oh, in the future. No, you're already a doctor. So my question is, so when you were talking about how exclusion of pregnant schoolgirls from education, I don't know why, we also have similar problem in Ethiopia, which is interesting because it's not only on school, but also in higher educational institutions. But then it also made me think of girls who were pregnant because of conflict-related sexual violence. We have many of them in Ethiopia, but we're not talking about them, unfortunately. So it's a question, and maybe it could be a recommendation. I was wondering if, because your session is on rewriting judgments, and you did your analysis using ECD framework, Ubuntu, as well as African feminism. So would it be maybe useful if you could kind of extend or include explicitly children who are born of rape, especially in conflict-affected areas? I could help you with the Ethiopian case because we're not talking about it enough. Because I think let alone to, getting protection or granting protection, we're not even talking about them. Maybe they need, visibility in addition, because we're talking about girls who are being excluded from school, but at the same time, the children are being affected. The children are being left out. The children, one of the issue is, what should the children's name be? The last name, because the girl doesn't know who raped her. And that is related to the Tigray war and the northern war that happened in Ethiopia. So thank you.
I hope Kelechi is still with us. Okay. Now, Kelechi, I have a problem with the problem that you have with pecuniary damages in the Ogiek case. Now, you call it a colonial vestige. If you go to the merits decision, you will realize that the initial problem with the Ogiek land issue begins in 1933 when Kenya was a colony. Now, the Cattle Land Commission that's cited in that decision was the first to dispossess the Ogiek and declare Ogiek land to be crown territory, which could be alienated and become subject to the torrent system of land ownership in England, so to speak, of individual titles. Now, yesterday, when I was having the discussion on the Ogiek case, I distilled 4 pillars as to why the Ogiek decision, the merits decision, is a landmark. And the first one relates to collective land rights and breach of Article 14 of the African Charter. The decision then gives new meaning to land ownership in the context of indigenous people. And for the first time, the African court is telling us who are indigenous people. And then what is the content of their right to collective land? That, of course, can only be remedied through non-pecuniary damages. However, the pecuniary damages are in relation to breach of Article 1, which was also an allegation that it had been violated, that the Kenyan state had violated its duty under Article 1 to recognize and respect the rights in the Charter. The third pillar that makes the merits decision landmark is in relation to breach of Article 22 of the Charter. Now, for that, the remedy is create a community development fund, and which that money will be used for things such as health and so forth, those social issues around the Ogiek community. Now, that money is to come from breach of Article 1 of the Charter. I hope we are following each other. So I look at damages as a remedy as being both restitutive and deterrent. Now here it is deterrent to the Kenyan state to avoid further breach of Article 1. It is restitutive in the sense that then it remedies the breach of Article 14 and Article 22. And then now, if you accept that the Ogiek position is a colonial problem, then I'd ask you a rhetorical or perhaps philosophical question relating to your title. Is there a problem of issuing what you call a colonial remedy to remedy a colonial wrong in a post-colonial era? Thank you.
Hello, everyone. Thank you. So my question is to Nobukosi. Thank you for that presentation, and I really loved the interesting angle that you presented with on. So my question is, because you expanded the scope of the remedy to also include the unborn child. And so now I'm thinking, at what point does a transformative remedy risk moving from judicial interpretation into policy making, especially looking at how the decision of the committee, for instance, if they had interpreted it in the way that you presented and the impact of that decision on similar cases? So how do you think the committee would have drawn that boundary? Thanks.
Okay. Okay. Maybe we should take about 5 because it's a bit. Yes. You then Tosin will be the last. Yeah. Give it to. Yeah.
So thank you so much. So my question is to Lasani, my comrade in the corporate accountability. So asked, the first issue has to do with when you mentioned that the court, used the UNGP, but did not then find the corporation liable. Don't you think that that is because the corporation is actually not, doesn't have that legal personality before the court? And in the respect of then, is the issue of that gap about the principle of corporation's responsibility of human right, or the issue is regard to forum? The fact that corporations are responsible for human rights violations is one question. The other question is about the forum to take them to. So don't you think that what we lack as we speak now is the absence of forum at the international level to actually take corporations to for the human rights violations? That's first. The second issue is regard to in that same case. So I noticed something in the case, which is when the court, I think in paragraph, specifically paragraphs 162, 231, 232, 247, 265, sub XVIII. So in those paragraphs, the court, when establishing the state obligation to prosecute corporations, it's consistently in those paragraphs mentioned entities and individuals. So don't you think, even though from those paragraphs, don't you think in your paper you can then make a logical conclusion that maybe the court is trying to establish that prosecution, which is towards criminal liability, can actually incorporate the entities and the individuals? Because I'm thinking that for the court to be so specific in this paragraph to say entities and individuals, then there must be something maybe in the mind of the courts, even though they were silent on some issues. Then the final issue is regard to the Malabo Court Protocol. I'm thinking that, so if you check, especially for corporate criminal liability, so if you check in Europe, for example, there are instruments that have established criminal liability of corporations, even at the UN level. You will notice that there is something that is common in this instrument at these two levels, which is when they say liability of corporations and they come to criminal liability, they leave actually the measure to the state to choose whether criminal, civil, or any other measure. But in Africa, which this Malabo Court Protocol is, I don't see that. So I'm thinking that, depending on how, I don't know. So I'm thinking that in Africa, at the international level, maybe we've taken a position that if the action of corporations is criminal, it has, especially when it then has to do with transnational or atrocity crimes, then it has to be criminal liability and nothing else, compared to what the UN is saying, giving state the liberty to choose whichever measure, and even what other sister mechanism, which is in Europe, is also saying, which is giving them the liberty to choose which other measure. So yeah, thank you.
Thank you for the wonderful presentations. My question goes to Lasani, my colleague. I wanted to just quickly ask, you want to use TOIL as a maybe as a lens in which you want to critique your paper, but there have been really serious problems and challenges with TOIL. First of all, it is said that it does not provide an alternative to the current international legal order, and also that it is sort of reinforces other Western theories, and that it contradicts itself by embracing the very notions of sovereignty and that are attached to colonialism. So I wanted to ask, do you perhaps maybe in your paper sort of look at other theories, maybe perhaps the FOIL, the fourth world approaches to international law, to sort of like complement TOIL and address the challenges that comes with it? Thank you.
Oh, thank you. We'll start with Kelechi. I think there was a question for you. Yes. Then we.
Yes.
Yes.
Once again, greetings to everyone. And the question came from the second person, and I'm grateful for your question. I penciled down some of the major points, having a judicial remedies from the colonial era in this post-colonial era, and he equally gave some vital articles from the African courts that are very much significant to the Genk case in Kenya. Well, first of all, let me kind of give a little disclaimer that I'm not really deep into the legal aspect. I'm not a legal person. I'm very vast in international relations and African geopolitics and African history. So that's what, influenced our understanding on the Ogen case. Well, also, I would like to quickly give a little breakdown in answering the questions directly that in Kenya, first of all, the African court issued the first big decision on the actual fact on the case. They ruled that the Kenyan government was guilty of violating the African Charter, and the court officially recognized the Ogenk as the indigenous population and stated that kicking them out of the Mao forest, which of course the question stated that happened in the late 1930s in the colonial era, violated the right to land, culture, and religion. Now, our paper tries to argue that that the Ogenk won the case, but the court messed up. The court, messed up by reasoning or sliding and separating their spiritual life from their cultural aspect to their inheritance and heritage in the land. Now, 5 years after deciding that Kenya was guilty, the court finally came back to announce that punishment and remedies, and this is what really happened. The court ordered the Kenyan government to pay reparations, 157 million Kenyan shillings, a total of 57 million to the material loss, and 100 and all of that, a serious reparation to be paid to the indigenous people. Now, our paper equally argued that the court to the attack is that multi-generational and existential displacement is flawed by the Western reflex, because in a way the African courts have not had this kind of case lengthy before. The Ogen case gave a kind of a classical example on how to deal with this recurring problem. In 2017, the court found Kenya guilty of violating the Ogen right, but in 2022, it failed the community by treating their deep spiritual displacements, as a standard financial transaction, meaning that the reparation, the displacement in terms of their cultural land inheritance can be easily paid out by financial transaction, and that's part of what we are arguing.
Thank you. I hope you're satisfied. Oh, okay. Okay. Oh, okay. Thank you. Another person? There were some questions.
Thank you. Thank you so much. Also, thank you. You were my eye contact during my presentation. Thank you for being so engaged. Yeah, no, I do think that it can be extended to us to answer those types of questions of what is happening to young girls that are becoming mothers and to their children. Of course, I think for this particular paper, it's a bit difficult because it's rewriting a very specific judgment and trying to work within the confines of that, but maybe thinking about how to make sure that if it was an ideal judgment, how it would apply to other contexts in a matter that is meaningful. So thank you for that. And to your question, I work in policy. So my everyday work is in policy. So this is a question that I have actually really grappled with when I was thinking through this paper. But I thought about it in two ways, really. And it's because it's something that has constantly been am I saying are the remedies now policy and crossing that line? But how I differentiated it in my thinking, and I'm so open to more input, is that when you consider whether something stays on the legal side or moves into policy, it's not just, it's when you're not telling, legal tells the state what it needs to achieve. When we go into the policy, you're now telling it how to achieve it. And this is not what this rewrite is doing. So firstly, every single order, it stems from an existing legal obligation that the state has. The rewrite doesn't create or invent a new obligation. It looks at the CRC, it looks at the charter, and it says, this is a state obligation. There's already a legal obligation for the state to provide childcare. And so that's all the rewrite does, is it highlights those obligations that the original decision didn't do. And then the secondly is it doesn't give specific orders. When policy would give specific things that it needs to do, here I just talk about the outcomes that we want the state. We want the state to provide childcare services. How it decides to do that, whether it opens an ECD center at every school, whether it pays for home care visits, whether it, gives a once-off cash subsidy, however it does it is entirely up to the state. But what the committee in this rewrite is saying is, however you do it, what must be done is you must provide effective childcare services so that the children who became mothers are able to continue with their education. But I am open to input.
Yeah, thank you. Oluwatosin, thank you for your questions. And I think your questions, highlight the fact that we should resume our bilateral conversation on corporate accountability under international law. And that being said, I agree with you. And also, I found it disappointing that the court cited when the court was trying to address the fact that Côte d'Ivoire violated the right to life in its interpretation of the fact, and also how the dump of the waste in Abidjan constitute a Côte d'Ivoire breach of the Article 4 of the Charter. And then starting from paragraph 139 to 141, the court included trafigura actions, and then cited the guiding principles as imposing obligations upon corporation to respect human rights, but the court did not conclude, and it concluded in the sense that Trafigura is responsible for those violations. The court concluded that even though Trafigura was the authors of those dumping of the waste and so on, Côte d'Ivoire is responsible for failing to uphold its due diligence obligations. Yes, in our rewriting, the way we proceeded with our rewriting is to try to avoid bringing in this debate on in which forum are we able to hold corporations accountable? Is it at the international level, UN, or where? And then we have tried to demonstrate that even though it's not expressly written somewhere, except the Malabo Protocol, when we use systemic interpretative methods, we can reach to the conclusions that being domestic courts or being international court, there is a room to hold corporations accountable. And the new TV case before the Lebanon tribunal is an example of that. And yeah. And also the fact that in Europe, we have been seeing that treaties are giving some margin to the state when it's come to holding corporates accountable to use civil, administrative, or liability tools. And I would disagree with you on your argument that at the African level we should stick to criminal liability, because in some cases, when it's come to handle it in a way that protect the individuals and the community, administrative means is important, and also liability means also can lead for a sound reparation for the community, which is at some point the much needed. Cassius asked that we use twill, and then he fears that using twill, there is a criticism that twill has criticized the first and the second conception of international law, but it has failed to provide a response to how it will make sure that it does not replicate the injustices that we are seeing within the first and the second world approach to international law. Within the guidance of Prof. Babatunde, I would say that we should consider that there is no single form of twail. That's why in twail, generally you will say that third world approaches to international law. Within twail, you can find criticism on how African states, while advocating for justices after independence, replicated the same thing that the colonial masters has been doing in Africa. And then it shows you the dynamics within twail. Yeah, and there are 12 conceptions that call for a holistic approach in providing responses to the injustice in order to take into account all the stakeholders in the African context, particularly the indigenous people situation in some countries. That's where you brought in the fourth world approach to international law, but I'm not a fan of the fourth world approach to international law. Yeah. Because I believe that the critics is good, but we can still continue interrogating what the fourth world approach is proposing, and what if within its responses also it replicate the same thing that the first and the second world approaches is doing. Yeah, then we can, my main argument is that we can stick to the third world approach and adopt an holistic lens of the responses to the issues we are facing. I thank you.
Thank you. Let's take a final round of questions. Yes. Any other taker? Yeah, yes. Yes, then we'll come to you. Did you raise your? Yeah, we'll come to you, yes.
Thanks so much. Cheryl Kanaka, Project Officer in the Women's Rights Unit here at the Center for Human Rights. My question is for Nobukosi. Thanks so much for really what I think is an eye-opening presentation. So I wanted to ask, you were making the argument that the committee had this information before them, the information that would have helped them make what you would argue is a better hand-on, a better judgment. I was wondering, someone yesterday, one of the speakers mentioned, and I'm paraphrasing here, that if we want better judgments, we have to plead better. And so my question to you is, do you think that the committee's judgment looks the way that it does because the pleadings did not take into account considerations of early child development? And if that is the case, then is the solution perhaps training for litigants who are bringing cases, any cases to do with children's rights before the committee? Do you think that maybe training would go a long way in making sure that the pleadings actually reflect all of the relevant principles that the committee should take into account? Because as you know, we often hear courts saying we can't we can't make a judgment based off of arguments you didn't put forward. So that's my question to you. But otherwise, really great presentation.
Thank you very much. My question is to Zulu as well, the same speaker. The question, and perhaps maybe tying it to the previous question that had just been asked, and I know you had put a rider in your presentation that the proposal to amend the judgment did not in any way, and perhaps maybe I got it wrong, maybe you might want to clarify, did not propagate the recognition of fetal personhood as a legal principle that ideally the committee should have. And if I got it wrong, perhaps maybe you might correct me, but my question would be, to what extent would the amended recommendations go to that level of propagating fetal personhood in recognition of the rights, ideally, as you put it, on early childhood development. And the context to which that question would be asked is, for example, there is a case that we are currently litigating in Tanzania, specifically, of young girls who had been particularly sexually violated by their own fathers during COVID. And they ended up pregnant as a result, and they sought to terminate those pregnancies because, one, their bodies could not be able to fully develop to carry that pregnancy to term because they were 11 and 12 years old. So if the committee was to make a declaration on that fetus as an unborn child, and that the state had an obligation to protect that, where does that lie in terms of that, just looking at it from that perspective? And maybe just to help you in answering the question on the pleadings, ideally you would understand why that recommendation would not come into the pleadings, because that would ideally then be propagating the extent to which fetal personhood should be recognized as a principle in which you protect prenatal life vis-a-vis the right of the adolescent girl who is ideally there. But I'm happy to have a conversation beyond that. Thank you.
Thank you very much for your insightful presentations. And my question is directed towards Lasane. I'm Martha Malialui. I'm a student at the University of Pretoria. And with that, I have a question related to your statement that the court's silence on corporations was an interpretive choice as opposed to a legal constraint. And with that, the court's grappling with the question of enforceability, to which you've proposed domesticating ECOWAS treaties. So on that basis, I would like to echo a similar sentiment that was raised. How do we reconcile corporate accountability with practical enforcement of liability? There's the angle of criminal liability, but there's also a general question of, is this not really a gap related to forums? And this is a recurring question. Is there appropriate forums to bring these entities into a space where they can be held accountable for some of the choices that they make, especially these economic choices? So I think with that, what would be your response to the lack of forums available to hold some of these entities accountable for their choices?
Thanks, Cheryl. So, yeah, I agree that partly it's because obviously the issue was not placed before the committee, and so they're going to make decisions based on that. But I would also argue that the child that was born was already there and existed, and even the child doesn't have to be before the committee for the committee to consider it in its decisions, because the best interest of the child, they should have considered. My argument is you can consider both children. Because that child is real, it's a part of the story, and you can make a decision that considers that child. But in considering the child that's born and the care obligations, it isn't actually just about the child that's born. And my argument is that if in failing to consider the care obligations that society places on these young mothers and ignoring the child that's born, the remedy that is given to the child that was before the committee is ineffective, because they actually won't be able to go to school if you don't recognize that they're now mothers with children that they need to take care of. So, but definitely we need to do better training and all that stuff, and make sure that these things do go before the committee and they can make better decisions. And thank you so much for your question. What a terrible case that you guys are going through. I'm so sorry for those girls and the work that you guys are doing. And so I'm going to read this because I've asked myself that question and I have drafted an answer to that question because I've really thought about it. Is this, and what I'm saying is this is not trying to, the debate has nothing to do with the unborn child and the rights or anything like that, that it doesn't even come to that. But what I was arguing is that the argument for it to stand, it doesn't depend on recognizing the unborn as a rights holder in any way, shape or form. The Charter's right holder remains the child after it's born, and it remains the pregnant mother. Before, in the first 100 days, it's the pregnant mother and the child after it's born. And the point that I focus on the 100 days is simply that the actions of the state, they affect the environment that child is going to be born in from the time that the mother is pregnant and the child is born. And I guess it's from an ECD perspective and lens where we want to focus on prenatal care. Focusing on prenatal care, the two can exist at the same time, of, the right to choose and all those things, without now entering into these other arguments. And that's not what this paper is trying to do. It's just saying that the state created conditions where young girls got pregnant, and then it punished them for that. And then it gave a remedy that didn't actually rectify the damage that those girls experienced. And so I think the committee can make an early childhood development consideration and ruling without touching on any other rights issues, especially in the case that you've just shared.
Okay. Yeah. I think you raised I don't know how to frame it, but this is a question I've been thinking about many times, and I received the same question from a judge from the African Court of Human Rights. She was asking, you guys are advocating for corporate to be accountable before my jurisdictions, but I don't want to write a decision which is not going to be implemented. And how am I going to make sure that the decision I have written is going to be impactful and I'm not writing nonsense? That was the question. And then and I've been thinking about it, but and in my mind, I was thinking about the Malabo Protocol of 2014. Let's say tomorrow we have the required number of states that have ratified the treaty, and it becoming to force. And then there is a corporate criminal liability case before these jurisdictions. How the implementation is going to be? It's still an unresolved issue even before that scenario. But what I'm thinking about is instead of relying on putting a lot of pressure on ourselves when it's come to implementation, I do believe that there is still a room for such kind of decision, also for such kind of outcome to be implemented. But it can be done within the AU bodies. That will be the political side of the African Union, being the AU Commission, the Council of the Security and Peace can adopt a resolution for the corporation to respect those decisions, or either they can put the corporation in a list, not a blacklist, but some sort of listing, and then to put a lot of pressure on them for them to contribute to reparation and so on. I think it's something that has been happening before the EU, the European Union, and if I'm not mistaken, even before the UN. There are some entities that have been placed in some list because based on jurisdictional decisions. I think it could be one of a way to implement those kind of decision. Yeah.
Thank you. Thank you. So because time is no longer on our side, so each of we're now closing the session. Each of the speaker, 30 seconds, quotable. It can be in any language of your choice, since we're engaging in this critical, this ontological quest to rewrite judgment. 30 seconds, your final shot. Make it very quotable, something we can cite on Instagram, on Twitter. Well, 30 seconds closing shot. Kelechi, may you start? 30 seconds, your final parting shot.
Okay, well, once again, I would say this is a great assembly, convergence of African great thinkers beyond the legal perspective to rewriting some of the landmark judgments that has affected Africa. Now, geopolitical trajectory for me is a massive privilege. And what my takeout point, my final shot to be, let's keep the conversation rolling. This is the right path, and before you know it, the spirit of Ubuntu will reign over us, and we'll get through our hurdles and make it as great Africans that we are. Thank you once again.
Thank you very much, Kelechi. I was expecting you to say it in Igbo, but yeah.
Forgive me, let me say it in Igbo. So, previous session, someone spoke Igbo and I was very proud. Ndị nwanne m ndewonu, ya gaziere onye ọbụla. That means my people, well done. Let it be well with everybody. Thank you.
Thank you very much. Thanks, Kelechi. Yes, your final shot. Why?
No, just that whatever remedy and judgments that whatever body is making should be practical and in real life situations, that we should get to put before the court the type of questions that force them to make a type of solution that will have lasting effect on the victims and survivors.
Thank you very much. And Lassen?
Yeah, my final words, I would like to paraphrase Judge Abela in the Neptune case. She was making the argument that international law, particularly international human rights law, is not a luxurious item. It's something that was designed for the living conditions of communities, and it was designed for the protections of human beings. And addressing corporate accountability, main objective is to contribute to the protections of human.
Thank you very much. Can we give a big round of applause to all our speakers? Yes, not only did they keep to time, but they've given us something to chew on. Thank you very much. Yes, thank you.
Thank you to our chair, and once again, thanks to the panelists. That was really, I think, a very insightful start to our rewriting dimension of this conference. Let us go for our lunch. It's about 10 to 1. Can we be back at 1:45, please? Because we are running quite a bit late and some people have departures and so on. So 1:45, that's almost an hour. Thank you very much. Let's try our best. Okay.
Okay. So I guess you didn't hear anything of that, but or some of you did hear in the venue, but not online. So we are starting now our last session, rewriting session on structural harm, structural power, gendered harm, and reparation. We have. Unfortunately, one of our participants, who is listed on the program, couldn't make it, whether here in person or online. Lizzie was supposed to do the last presentation. Of course, she was also known as OGIEC 5. So I guess we just have to look at her paper later on. But here in the venue, we have Emma and Lakshita, who will look at various aspects in relation to the gender aspect, which I guess is also the origin or around rewriting judgments. And then we'll also have Henrietta joining online in relation to the committee's slavery case. But I think, Emma, over to you.
No. It's press it's Bluetooth connected.
Good afternoon. I'm called Emma from Uganda, and I'll be rewriting the ELISA judgment. I'm currently at the University of Greenwich. Sorry, I'm trying to just get used to how to operate this, but I'll figure myself out. But before that, I really want to thank the organizers of this conference for the opportunity for us to gather here in this space to really share our thoughts about, the African union system, but most especially to learn from everyone that has been presenting, just sitting in for the past 2 days. Like, I've gathered so much knowledge. So thank you to everyone as well that has been presenting. So, is this it?
Yeah, just like that.
All right, so that's a summary of my presentation. I don't know how quickly we'll get through this, but wherever we stop, we will end where we stop. Before I get into the rewriting, I think it's important for us to understand the facts and how they played out. So, and even as I engage with the facts, I'm going to focus on the facts that led up to what I'm rewriting about. My rewriting focuses on the applicant's issue on the violation of her right to terminate a marriage. So on 4th June of 2014, she filed a case before the Ariana court, in which she sought to separate from her husband. The court actually granted her the divorce and also custody of the children and alimony, which is financial support. So what followed was on the 10th of June, where the applicant's husband appealed the decision before the Tunis Court of Appeal. And of course, on 1st June, the Court of Appeal upheld the decision on divorce, but then overturned the decision on alimony and child custody. Come 16th of June 2016, the applicant, Elisa, is dissatisfied with the Court of Appeal decision. She appeals that decision before a court of cassation.
On 7th of December, the Court of Cassation dismissed her claim. What is interesting to note here is while these proceedings were actually going on, there were parallel criminal proceedings that were also happening. Now, on 8th November, the applicant, while traveling with a man called Hannibal, were followed by the applicant's husband. And when the husband saw them enter a room, he called police on them. They were charged with adultery. And on 12th of December, the prosecution instituted adultery proceedings against the applicant and Hannibal. And on 9th of December, they were convicted and effectively sentenced. Of course, the applicant and Hannibal appealed the decision, the criminal decision, and the Court of Appeal dismissed it, upheld the sentence and upheld the conviction. On the 10th of April, dissatisfied with that decision, of course, because judgment had already been entered, she thought she would actually find a remedy by lodging a complaint against the public prosecution and how her case was handled. That case was really never heard. To cut the long story short, she approached the African Court of Human Rights. And there were a number of issues she took issue with, one of which was the right to fair trial, which the court actually held was violated. The other issue was the right to terminate her marriage, which the court said was not violated. Her argument in that case was that when the court handed down the decision on the 4th of June, 2014, her marriage had long ended. And so she found it problematic that after that, adultery proceedings were instituted against her. She felt that the continuity of the marriage after she thought it had ended on 4th of June 2014 was a violation of her right to terminate a marriage. Of course, one of the critical provisions that the court was actually dealing with in this case was Article 7. And what the court had to decide was whether that, amongst other provisions, had been violated. The provision states that women and men shall have the same rights to seek separation, divorce, and annulment of a marriage. Now, this is what the court actually held, and it basically regurgitated what the court in Tunisia had said. The court in Tunisia had actually said that if the spouses appeal the divorce judgment, the marital bond between them continues, and the filing of a case of adultery against one party is valid as long as the judgment has not become final. And so the court actually said that there's really no discrimination against Elisa, the applicant, because this provision and the law on divorce in Tunisia applies in the same manner to both men and women. And so on that account, the African court found that there was no violation. This decision is a good decision, one would say, depending on what lens you actually look at it. The applicant committed adultery in terms of the laws of Tunisia. When you commit adultery and there's evidence to support that, you will be prosecuted. And so the court was right on that because there's a law. In as far as the principle of non-finalization, as long as there has been an appeal, this is a principle that cuts across both men and women. So to that effect, it applies to both men and women. So it cannot be argued that it discriminates against Elisa, the applicant in this case. There was actually also precedent on how the court actually deals with these issues, one of which is the case of Alex versus the United Republic of Tanzania, which is to the effect that it's not the business of court to act as an appeal court. So it is justified for the African court not to venture and meddle into the affairs of Tunisia. And of course, women and men shall have the same rights, and effectively, Elisa had the right to appeal. She appealed, the court decided, and based on that decision, it cannot be said that Elisa was denied the right to terminate the marriage. But as said, that decision is correct depending on what lens you look at it. And the framework within which I'm writing this judgment is the African feminist writing methodology. And based on that methodology, there's huge problematic issues with this decision. What is the feminist judging methodology? This methodology has been around for some time. The literature that I've engaged with actually traces it back to Canada in the early 90s, where female academics actually, having advocated and called on courts to change the manner in which they decide issues pertaining to women, and the court was not responding, decided to take issues in their own hands and decided to start rewriting judgments to show the court that, okay, if you can't do it, let's show you how to do it. And so they rewrote judgments. This practice was actually transported to other jurisdictions, including England and Wales, where a number of academics and advocates actually rewrote judgments of the Supreme Court of England and Wales. The same practice was used to rewrite a number of European court judgments. A number of judgments have also been written from the international law perspective. In the United States of America, a number of judgments have still been written, amongst which is the case of Roe versus Wade. When you look at all these judgments and you look at all these projects, I had an opportunity to scan through about 20 judgments from these projects. And there's patterns that can be discerned from these projects. What these people are actually saying is that when you're dealing with cases that pertain to women, you need to put on a feminist lens. And across these judgments, there's themes, there's habits, there's techniques that cut across how these judgments are actually written. One of the things that cuts across these judgments is the emphasis on substantive equality, where emphasis is placed on the fact that we should not look at the fact that the laws applies in similar manner to all people. We should look at the outcome. We see that in the case of YL, where in rewriting the judgment, the court actually looked at the outcome of the rules that seemed to be neutral in actual fact. The other thing that cuts across these judgments is the fact that they tell the story of the woman holistically. They look at the context, they look at the circumstances, they do not just look at the rules. We see that in the case of Royal Bank of Scotland, which was again another rewritten judgment in England and Wales, where the court actually said that, let me just briefly track back in as far as the facts of this case was concerned, as I catch my thoughts as well. So what happened in this case was the husband borrowed money from the bank and used the home property as collateral. And when the court that decided this case in determining whether the husband should pay back or the house should actually go to the bank, the court just looked at it as a legal transaction. The academic that rewrote this judgment said we cannot just look at this as a contractual obligation. This house is a marital home. And to that extent, we need to bring into perspective the woman who is the wife of the man who borrowed this money. And so they looked at that context. They looked at the fuller story. And that is how most of the feminist written judgments actually look like. The other feature that runs across all these judgments is the type of sources that they use. They use black letter sources like your treaties, like your cases. But one of the things that cuts across all these judgments is the fact that they look beyond. They look beyond your judgments, they look beyond your treaties. They look at reports, they look at empirical data, they look at work of scholars. Why do I find the Elisa judgment problematic from a feminist lens? Because I believe when they were approached with a case that touched on the rights of women, they should have worn feminist glasses. They looked at this case from a through a formal equality perspective, which is problematic. And this is why I say it was problematic. When the court was actually deciding that there was no violation, what the court said was, okay, you had a right to institute proceedings as a woman, you instituted them because you are not denied that right. You had the opportunity to appeal, no one stopped you from appealing. The rules actually say that once a divorce judgment has been appealed, the decision is reinstated, and that rule applies across. What the court failed to see was that on the 4th of June of 2014, the judgment was actually handed down. On the 10th of June of 2014, the appeal was instituted. On the 8th of June of 2014, the applicant's husband decides to institute adultery proceedings simply based on the fact that this marriage had been resurrected. And it's on that basis that the adultery proceedings were actually reinstituted. And so the court fails to see that the court actually fails to see that these adultery proceedings were actually being weaponized to sabotage the family law proceedings. So what we see here later is the decision to overturn on 1st of June 2015 came after the decision finding the applicant guilty of adultery had been handed down. So this decision effectively influenced how the court deemed the applicant's readiness to have custody over her children, the applicant's readiness to entitlement to alimony. We all know that in family matters, the decision on whether a woman should be entitled to alimony or husband should be entitled to alimony, especially in fault-based proceedings, divorce proceedings, have a lot to do with fault. So if they find fault in you, chances are high you will not get alimony. So the effect of criminal proceedings was to impute fault on the woman, effectively influencing the decision on 1st June of 2015, in which the court upheld the divorce and overturned the decision on alimony and the decision for the woman to actually have custody over her children. All the court actually did in deciding this case was to say, oh, you appealed, you applied for divorce, divorce was granted unto you, no one stopped you from appealing. The court failed to see all these surrounding circumstances. And in holding that these rules apply equally to men and women, the court was failing to look at the outcome, the effect of these proceedings in as far as the rights of women are concerned. So one of the things I fault the African Court for is failure to look at this decision from a substantive equality perspective. The other failure is to look at the story of Elisa holistically, because like I said, a feminist approach to judging is one that looks at the story holistically. It doesn't just look at the rules, whether the rules were followed. It looks at the surrounding circumstances, ensuring that the story is actually brought full circle. In failing to see how these different dates played around to disadvantage the applicant, Elisa in this case, the court failed to actually tell Elisa's full story, which I find problematic. The other feature of feminist judging, like I said, is the desire to actually look at sources beyond your traditional sources. And what we see in the judgment, the court basically looked at the UDHR, the court actually looked at the Maputo Protocol, despite the fact that there's an abundance of literature, there's an abundance of general comments, there's an abundance of feminist scholarship that would have debunked the position of the court. And I find that problematic. And so I rewrite this judgment from a feminist perspective, taking all this critique into account. But even in rewriting this judgment, my view is that it's problematic to transplant this approach to Africa directly. My position is that we should adopt an Afrofeminist judging methodology. As far as I know, there hasn't been any study that has approached feminist judging methodology from an Afrocentric perspective. All the judgments that we have looked at from Canada, from England, and Wales, from the US, and the individual judgments that have been written, they have been rewriting judgment and drawing on all these practices. The one thing they haven't done is to look at the unique circumstances of Africa and how that can actually inform how we interpret and apply feminist judging methodology. And in theorizing what feminist judging methodology, what do I mean? One of the things that I'm saying when we say Afrofeminist judging methodology, for me, it means reclaiming our histories. It means acknowledging colonialism. It means not pretending like all these things like telling a story are unique to the global north. We have been telling stories all our lives in Africa. So when I think about Afrofeminist judging, all I'm saying is let's claim histories. Let's take into account our history. Let's take into account our diversity. Let's take into account the effect of imperialism that continues to impact on the rights of women on the African continent. In as far as telling stories, like I said, is concerned, oh, wow. Let me quickly run through. As I rewrite the judgment, my perspective is we need to actually draw on our own sources and draw on our own history. When it comes to wider sources, as we write the judgments, we have a wealth of literature. We have feminist scholars like Tamale. We have feminist scholars like Amama, and all these authors need to come into play. We have general comments that the court did not bother to deal with. I want to quickly get you onto the judgment in the last minute. So in rewriting the judgment, I did not write the entire judgment. I edited the judgment. So all I'm trying to say, as I rewrite this judgment, I'm trying to tell the court, you didn't get everything wrong. There are certain things you got right. But if you could have tweaked a few things here and there, you could have gotten it right. And as I do this, in ensuring that I show the court that this is within reach, I draw on its own jurisprudence to pivot into Afrofeminist judging methodology. And so here's where we start, where because the African court has no appellate court above it, in rewriting this judgment, I assumed the role of the president. So I sat on this bench and assumed the position of a judge that decided this case on the 4th of December. And so I became the president and replaced the president at the time. And as you can see, what is in bold is what I'd added. What is not in bold is what was originally decided by a court. So what I'm trying to do here is that the decision could have done with a few tweaks to actually ensure a feminist judging approach. And when I talk about telling the full story, as we can see in the paragraph in bold, my aim is not for you to read everything in bold. But what I was trying to capture there is, as a feminist judge, there was a critical need to tell Elisa's story holistically. And one way of telling her story is to trace back the source, for example, of the adultery law. This is a colonial era law that we cannot pretend like it's not a colonial era law. And so I locate Elisa within the wider structure of patriarchy. And so as I rewrite, that is one part that I feel the court missed that could have properly put this decision into context. And of course, as you can see, I retain the other paragraph. But later on, as you can see the dots there before paragraph 1.7, I pivot. And those are the parts of the judgment that I delete and replace them with my own judgment. And again, as we can see, I retain their judgment as much as possible because I'm acknowledging that there are things that they got right. But then I draw on court's own jurisprudence here to pivot into Afrofeminist judging. In the case of Alex Thomas, for example, here says that though this court is not an appellate court body, with respect to decisions of national courts, this does not preclude it from examining relevant proceedings in national courts. So this decision in itself helps me to pivot into and to question the Tunisia's proceedings. And it is on this basis that I start to question the decision that the rules on the pendency of a divorce after an appeal has happened is something that the court could have interrogated if it did want. And so it is on that again start drawing on other decisions. And so I use court's own jurisprudence to pivot into Afrofeminist judgment. I center the African Commission's own jurisprudence, again, to show the court that this decision is within reach. It is not magical. It's not something that you needed to outsource. The decisions were already there. For example, I draw on the decision of J versus Namibia that had already set the pace of substantive equality. This decision was handed down in 2024. The Elisa decision was handed down in 2025. So there was already grounding that the African court could have drawn on. And so I hop onto J versus Namibia, to then buttress the issue of substantive equality, which is a key feature of feminist judging methodology. Again, I also use wider sources because wider sources are critical. And these are not something that you need to wait for the different counsel that are actually deciding these cases. The issue is before you. You already have Namibia case that is telling us about substantive equality. And we see here that, again, I'm drawing on wider literature. I'm drawing on Sylvia Tamale, and one of the things that stand out in Afrofeminist judging is the readiness to draw on literature, is the readiness to actually draw on other sources. I draw on general comments that actually define what substantive equality is concerned, to then paint the picture of, you know what, this case could have decided differently from paragraph 106. If you had only taken a slight turn and drawn on your own jurisprudence, you could have arrived at a different decision. And so we see here that I draw, for example, on the work of Tamale, I draw on the work of Namibia, which is still within reach of the African court. In the next paragraph, the bold is still my addition, where I use wider sources like General Comment 6, which was within reach of the African court, but the African court did not bother to engage with. I draw on empirical data, and like I said, for me, an Afrofeminist judging methodology is one that draws on the rich sources of Africa. And here, I draw on Himonga. Himonga has done a lot of research on the effect of divorce laws on women, particularly the fact that we have neutral laws that look neutral on paper, but the outcome is different because they end up marginalizing women. And so I tie this empirical work of scholars like Himonga, like Tamale, into the argument that then buttresses the point that what we are looking at in as far as the Elisa judgment is not an issue of how rules apply equally to men and women. The issue is a chronic issue that literature supports, that the African Commission's own jurisprudence actually has questioned and supports. As I wrap up, one of the key features, again, like I said, that Afrofeminist judgments actually place emphasis on is telling the woman's story. And here I dive deep into telling the woman's story. And again, I draw on the general comments of the African Commission, but then I tell the story that I've been telling you in I'm basically trying to bring this story full circle in that judgment, where I'm telling I'm moving that into the judgment to show that this context does not look like what we're dealing with is just rules. What we're dealing with is not just adultery rules. What we're dealing with is not just rules that apply equally to men and women. What we're dealing with is structure issues. A woman that is being subjected to a colonial era law that hasn't been amended, a law that puts her in a structure of patriarchy where criminal proceedings are actually being misused for purposes of sabotaging her proceedings in a family law matter. So I bring that full circle. And ultimately, I arrive at the decision that there was a violation. And as you can see, I edited that part. As you see at paragraph 124, the court had said there was no violation, but having looked at substantive equality, having told the story of Elisa full circle, having drawn on African literature, which are all key features of the feminist judging methodology, I arrive at the conclusion that there is no way you will wear that lens and arrive at the decision that the African court arrived at. Thank you.
Thank you very much. Emma borrowed a little bit of time from Lizzie, who's not here but you can see her full argument also in the folder where Judge Dubale is setting out the full arguments of the case. So over to.
Okay. Oh yeah. Only one slide. Great. Thank you so much. Good afternoon, everyone. In as much as I will expect you to give me feedback on my presentation, my main purpose as well here is to help the mechanism in engaging in more scholarship to help receive more progressive and better language when it comes to feminist jurisprudence, a conversation we've been having since yesterday about women's rights cases before the mechanism. So my presentation today is about the
rewriting of the African Commission decision in Senate Masufa and others versus the Kingdom of Lesotho. By way of introduction, I'm Lekshita Kanhia. I serve at the Initiative for Strategic Litigation in Africa, also known as ISLA, and I'm also a doctoral researcher at the Center for Human Rights. I have only one slide, so just to make you familiar of what I'm going to speak today. So the Secretary of the African Commission received a complaint on 10 September 2014 from Ms. Senate Masufa, the first complainant, the victim of the alleged violation, who made this complaint on her behalf and behalf of all other firstborn daughters in Lesotho. The second complainant is FIDA Lesotho. The third complainant is the Southern Africa Litigation Center. The complaint is submitted against the Kingdom of Lesotho, which is the respondent state party to the African Charter on Human and People's Rights. So the complaint challenged the constitutionality and legality of Section 10 of the Chieftainship Act 22 of 1968, which exclude firstborn daughters from succeeding to chieftainship. The complainants argue that the exclusion of firstborn daughters from succession to chieftainship constituted discrimination and violated numerous provisions of the African Charter, including Article 1, 2, 3, 5, 13, 14, 16, 17, and 18, as well as Article 2, 3, 5, 8, 9, 13, 14, 17, and 21 of the Maputo Protocol, the Protocol to the African Charter on Human and People's Rights on the Rights of Women. So the African Commission declares that the respondent state is in violation of Article 1, 2, 3, 13 of the African Charter and Article 2, 3, 8, 9, 17 of the Maputo Protocol. So I want to start with a sentence, but also to give a background why this is part of the rewriting. From the Commissioner Lumbu dissent, that for me explain why feminist judgment writing remains so necessary. So among his dissent, he warned that the commission decision reflected feminist militant ideas and even wondered whether it was the product of a commission composed of 6 women and 5 men. We've been having this conversation yesterday about the bench. So that statement does more than disagree with the outcome. It suggests that when women shape human rights jurisprudence, their reasoning become ideological rather than judicial. Ironically, however, while the majority reached a positive outcome, it did not fully develop a feminist jurisprudence. It condemned discrimination, but it stopped short of exposing the structural relationship between patriarchy, customary authority, and state power. So my rewrite, therefore, takes the dissent seriously, not because it is persuasive, but because it reveals precisely why feminist judging is still required. Not simply to place women on the bench, but to transform the way law understands power, culture, and equality. The commissioner also criticized the commission for deciding the case too quickly, suggesting that it should have delayed the matter again, sought further amici, and resisted that what he described as the push of ultra-progressive feminist ideas. But this communication was filed in 2014, and the merits and it was only published in 2025, 11 years later. For women seeking justice before the African human rights bodies, delay is not procedural caution, it is structural injustice. We've been having this conversation yesterday about the few women rights cases we've been having. More troubling, even after 11 years, one of the few women's rights cases before the African Commission stopped short of producing a truly transformative feminist jurisprudence. It's a missed opportunity of how I classified it. If African human rights institutions hear so few women's rights cases, we cannot afford judgments that merely identify discriminations. We argue that we need judgment that expose the structures of patriarchal power that sustain it and articulate a genuinely transformative vision of equality. And in this case, we are speaking about chieftainship, and we see that discrimination just because she's a woman. This case illustrates a subtle form of judicial avoidance. The commission was willing to identify discrimination, but reluctant to interrogate the structures of power that produced it. So as a result, the judgment condemns the system without the symptom without fully exposing the legal architecture of patriarchy that sustained women exclusion from traditional authority. So the question that motivated me to rewrite this was not whether the African Commission reached the correct outcome. In my view, it did. Rather, I asked a different question. So what would the judgment have looked like had it been written from an explicitly feminist understanding of state power, structural inequality, and living customary law? So my submission is that the original judgment reached the right destination, but traveled an incomplete jurisprudential path. While the Commission correctly held that Lesotho violated the African Charter and the Maputo Protocol by excluding firstborn daughters from succession to chieftainship, it did not fully theorize the relationship between customer authority, state responsibility, structural gender subordination, and public power. So those omissions became particularly visible when read alongside the dissenting opinion of Commissioner Lumbu. The dissent is significant because it reflects a recurring anxiety within the African human rights jurisprudence. He cautioned that subjecting customary succession to African Charter review risk transforming human rights law into an instrument for policing African culture. He questioned whether the Charter was intended to function as a corrective to African customary institutions, and warned that the majority reasoning could ultimately expose religious institutions, customary communities, and other sites of cultural authority to human rights scrutiny. So that framing is itself very problematic. It assumes that culture exists independently of power. It assumes that customary institutions are politically neutral. Most significantly, it renders invisible the women whose exclusion constitute the very mechanism through which those institutions are reproduced. So as my previous colleagues since yesterday have been speaking about feminist jurisprudence, it has long demonstrated that law frequently naturalizes relations of domination by presenting them as tradition, family, religion, or culture. Power is often rendered invisible precisely because it appears natural. So African feminist scholars have demonstrated that appeals to culture frequently conceal historically contingent patriarchal arrangement while presenting them as immutable to African tradition. So my rewriting judgment sections are divided into 4. I'm not going to elaborate that much. My paper is available, but I just want to briefly take you through what I've been arguing. So the first one is state responsibility and attribution. Second, customary authority and living customary law. Third, the public-private distinction under the Charter. And fourth, substantive equality and women participation. I think we've been hearing a lot about substantive equality over the past 2 days. So first, the state responsibility and attribution. So the rewrite rejects the premise that this case presents a conflict between culture and equality. Instead, it reframes the dispute as a question of state responsibility for institutionalized gender hierarchy. So the question is not whether customary communities are directly bound by the African Charter. It is debatable. Nor is the question whether customary or religious practice becomes susceptible to international adjudication. Rather, the question is whether a state may enact legislation that gives legal force to customary rules which exclude women from recognized public authority solely because they are women. Once framed in this way, the analysis changed fundamentally. The office of the principal chief is neither a private familial position nor merely a symbolic cultural office. It is established, recognized, and regulated through legislation. Chief exercise public authority within Lesotho constitutional order. So accordingly, the discrimination is attributable, not simply to custom, but to the state itself. This aspect of the rewrite draws explicitly upon the Commission's own jurisprudence. In Amnesty International and others versus Sudan, the Commission made clear that states cannot evade child obligation through institutional arrangement that distance violation from formal state action. Similarly, in Izzat Inayat versus Egypt, the Commission recognized that states remain internationally responsible where domestic legal frameworks perpetrate discrimination through ostensibly private or religious system of personal status law. The second intervention concerned living customary law. So one of the weaknesses of both the majority judgment and the dissent is that each in different ways treat customary law as relatively fixed. The rewrite instead adopts the conception articulated by the Constitutional Court of South Africa in Shilubana versus Nwamitwa. Shilubana fundamentally transformed the jurisprudence of customary law by recognizing that African customary law is not fossilist, historical practice, but a living normative system capable of development by the communities who observe it. So this insight is particularly significant within feminist jurisprudence. If customary law is genuinely living, then patriarchy cannot be defended merely because it has existed historically. Neither history nor repetition is sufficient to legitimize gender hierarchy. So the rewrite further situates this reasoning within African human rights jurisprudence by drawing upon the Andres versus Kenya and the African Court judgment in Ogiek, both of which conceptualize culture as dynamic, evolving, and responsive to the lived realities of African communities. So African women are not outsiders to culture. They are participants in its creation, preservation, and transformation. While Article 17 protects cultural life, it must be read together with Article 2, 3, 18, which guarantee equality and non-discrimination. So the Charter, therefore, protects culture precisely because culture is capable of transformation. It does not constitutional patriarchy. A further intervention concerns substantive equality. The original judgment correctly identified direct discrimination. The rewrite asks a deeper question. What structures of power are reproduced through this exclusion? Section 10 of the Chieftainship Act does not merely prevent one from becoming chief. It institutionalizes a gender distribution of authority. It determines who governs communities, who exercises jurisdiction over customary affairs, who participates in land governance, who represent communities before the state, who is recognized as a legitimate political power. So the respondent state has offered no objective and reasonable justification for the blanket exclusion of women from succession to chieftainship. The invocation of culture alone cannot justify a statutory rule that denies women equal access to public authority. So the injury therefore extends beyond formal exclusion. It reproduces what feminist scholars identify as a structural allocation of political authority along the gendered lines. And the distinction between public and private becomes particularly important here. The communication concerns a statutory regime governing succession to legally recognized chieftainship. The Chieftainship Act gives legal effect to exclusion from public office. The office of chief carries legal recognition and public significance. So the state has chosen to recognize and regulate that institution. So once the state does so, the institution is no longer located within the private sphere. So as feminist legal theory has constantly argued, the public and private divide has historically functioned as one of the law's most effective technologies for rendering women subordination legally invisible. So the exclusion of women from traditional leadership is often characterized as an internal family matter or a cultural question. So the rewrite shifts the focus from a perceived conflict between culture and human rights to the real question before the Commission, whether a state may lawfully maintain a legislative framework that excludes women from position of recognized authority solely because they are women. Framed in this manner, the case becomes not an attack on African culture, but a defense of African women equal citizenship, dignity, and participation in public life. So in terms of remedies, the Commission did provide remedies, but from the rewriting, a feminist understanding of remedies require more than correcting an individual injustice. I think we've been also having conversation about individual complaint and so on. So it requires transforming the institutional condition that made injustice possible. For that reason, the rewriting judgment recommends not only amendment of Section 10 of the Chieftainship Act, but broader structural remedies, including legislative review, institutional reform, engagement with traditional authorities, support for women organization, and recognition of Ms. Masufa's succession under a constitutionally compliant framework. So in conclusion, I suggest that the significance of this rewrite extend well beyond Senate Masufa. The rewriting judgment seeks to provide a clearer account of why discrimination embedded in a customary succession system becomes attributable to the state once that system is recognized and regulated by law. So across the continent, we are witnessing renewed assertion that culture, religion, and tradition requires resistance to gender equality with the nation of family and so on. So this rewrite demonstrates that African human rights law already contains these jurisprudential resources necessary to reject that false choice. The African Charter and the Maputo Protocol do not require African societies to choose between culture and equality. Rather, they require us to understand culture as a living institution whose legitimacy depends upon its capacity for inclusion and dignity. Feminist judging, therefore, is not simply about changing outcomes. It is about making visible the structures of power that conventional legal reasoning leaves obscured. So it asks different questions, it identifies different harms, and in so doing, it imagines different possibilities for African human rights jurisprudence. So this case was more than an individual complaint. Senate Masufa and others versus Kingdom of Lesotho presented the African Commission with a rare and important opportunity to produce a transformative African jurisprudence of women's rights, customary authority, and democratic participation. It was an opportunity to shape the constitutional future of customary leadership under the African Charter. Although the Commission reached the correct result, it missed the opportunity to develop a coherent jurisprudence on living customary law, structural gender inequality, and state accountability that could have guided future litigation across Africa. So this rewriting exercise is not simply about imagining how one judgment could have been written differently. It is about imagining the future of the African human rights jurisprudence. And so today, my role as well is kind to share, to contribute to scholarship, I should say, because it's going to be published, that we need to continue to engage, encourage, and also invite the African Commission to engage more deeply with feminist legal theory, feminist scholarship, gender equality, African feminist thought, and substantive equality language and jurisprudence, so that it can also be reflected. Because yesterday we were having a conversation about case framing. We were speaking about the role of the litigants, and I also want to argue that the Commission as well has a role, the court has a role, the committee has a role to also engage and research how to do better response framing as well, in as much as litigants will be doing the role. With the J versus Namibia, we've been seeing how the intersectionality has been reflected And in as much as litigants also will do the research, we also want to have this, this commitment from the mechanism. So these are not abstract academic debates. They shape how cases are framed, how harms are recognized, and how remedies are conceived. So for this is especially urgent, I should say, at a moment of global and regional backlash against women's rights, where appeals to culture, religion, and tradition are increasingly mobilized to resist gender equality. Women's right communication before the African Commission, we've been speaking about it, remain relatively few. So every case, therefore, is a jurisprudential opportunity. And so among my other colleagues who presented our feminist judgment since yesterday, we cannot afford that we cannot afford to receive judgment that just merely find violation. We need judgments that develop transformative feminist jurisprudence capable of guiding courts, advocates, and communities across the continent. Thank you so much for your attention.
Thank you very much. In between Emma and Lakshita, you use up Lizzie's time as well. So Henrietta, over to you. Please, 15 minutes.
Hi, everyone. Good afternoon. And thank you to the organizers for putting this together. It's been a very rich couple of days listening to everyone's presentations and all the interventions made so far. I'm going to just quickly try to share my slides from here. Or simply wait, can you put it up for me and then I regulate it from here? Because I'm not seeing the option to. It's not letting me click on the option continue to share.
I think we'll share it from this side. But you can start talking to me. Yeah. Insights on your application.
So it's not letting me continue or stop sharing. Not sure what the. Okay. I've stopped now.
Okay, I'll share from my side and then we'll just continue. You can start talking.
Okay, awesome. Thank you so much. Hi, everyone. Thank you again to the organizers and shout out to my panel members. It was really good listening to your contributions. My name is Henrietta Ikefre. I'm an independent consultant specializing in human rights, gender equality, and reparations in light of transitional and transformative justice. And I'm delighted to be presenting as part of this session, which is basically focused on structural power, gendered harms, and reparations. I think it's really interesting that those three issues speak to what the decision I'm rewriting is about. So the decision I'm writing is a 2017 decision from the African Children's Committee of Experts on the Rights and Welfare of the Child. And it basically was brought by MRG, so Minority Rights Group International, and SOS Enclaves versus Mauritania. And it's a case of Said and Yad Salem, who are young boys that were held in slavery for about 11 years. To set the context for this presentation, so just to go ahead before coming back to the slide, the crux of my paper is basically using third world approaches to international law, which has been debated earlier in the previous session, and the reparative justice to redefine what the committee could have done differently in this decision, despite it being a good decision, as it were. So now to the case. Mauritania is one of the last countries in the world to have formally abolished slavery as of 1981. And in 2007, it criminalized slavery. Despite this abolition, the practice has continued. And in this case, for the two children, the Heritin caste system that exists in Mauritania basically has allowed for a descent-based class of people, 10 to 20% of the population, who are enslaved by virtue of their status, and most of them are inherited slaves by virtue of their mother's status as slaves. So a child born to a Heritin mother is automatically enslaved. For 11 years, Said, born in 2000, and his younger brother, Yad, born in 2003, were considered properties of the El Hassan family, and they went through, despicable treatments, labor, not receiving schooling, no play, ate leftovers, etc., etc. Eventually, they escaped in 2011, and their aunt filed a complaint that was then followed with one conviction, some imprisonment terms for a member of the El Hassan family and his sister. However, the convicted slave owner was granted bail and absconded. The appeal of the case at the national level stalled for about 4 years, and the boy's mother was simultaneously prosecuted, both as victim and perpetrator, for allowing her children to be in that system, which is an irony in the case and a contradiction that the committee does not speak to. I must just quickly state here that while understanding that the committee is a committee for children, the committee had an opportunity to address the gendered aspects of this harm, which I'm going to get into much later in my presentation. We can move to the next slide, please. So in terms of the complaint and the decision, the committee did find violations of key articles. So Articles 1 on the obligation of state parties, Articles 3 on non-discrimination, 4 on the best interest principle of the child. It goes on and on till Article 21. For the purpose of this presentation, I'm only going to focus on 3 articles, Articles 1, Articles 3, and, and Articles 21. Article 1 is framed as a due, and so the reason I focus on this is because my analysis is that these 3 articles, the analysis of the violation is where the committee had room to establish more jurisprudence and missed that opportunity. So essentially, with Article 1, it is framed as a due diligence failure. The committee relies on previous jurisprudence within the African human rights system, where it basically says that Mauritania did investigate, right? But failure to prosecute adequately was the violation on the part of the state. But I go on to say that it's more than that. It was more than an enforcement problem, but a structural one. And the committee did not ask about the conditions that sustain the system and what dismantling them would require. So Article 1 goes beyond due diligence to actually creating the room for structural transformation of the situation that causes the violation. The second article is with regards to Article 3 on non-discrimination. And the analysis the committee gives for this violation is the differential treatment of the boys in that household. They were fed leftovers, they were beaten, and went through a lot of, ill treatment. But it misses the point of the Heritin caste system, which has colonial origins and has an intergenerational structure and reaches across hundreds of thousands of people. And so treating that differential treatment as a factual background did not give it room to adequately analyze the structural legal category that these people fall into and how that is a problem beyond Said and Yad in this case. And with regards to Article 21, the committee finds a violation of the African Children's Charter, which speaks to harmful traditional practices. But again, was silent on the mechanism of this harmful practice, which is matrilineal hereditary transmission of enslavement. And essentially, this is, I think, the committee's most significant missed opportunity in this case, because this is where the gender analysis belongs. And because of this structural interpretations that were missed in the committee's analysis of the violations, it speaks to the merit. So the merit is about 15 recommendations that are quite detailed, but there was room for it to be a bit more structured, given the 5 pillars for reparations from the UN Basic Principles that I'll be referring to much later. Please, let's move to the next slide. So in terms of the tools that I use to frame the arguments in this paper, first, third world approaches to international law TWIL, that's my interpretive lens. The central question TWIL asks is, what does formal law obscure? Applied here, it reveals that the African Children's Committee's due diligence framework, borrowed from European and international human rights law, developed for context where state actors are the primary violators, neutralizes the colonial arguments. It treats hereditary slavery as a legal enforcement problem rather than a structural inheritance of empire. 12 reframes the central question to not did Mauritania investigate and prosecute, but to what colonial architecture sustains the Heratin caste, and what does the Charter's interpretive framework demand in its dismantlement. And for my normative framework, which is based on reparative justice, basically relying on the UN Basic Principles and guidelines on the right to remedy and reparations adopted by the UN in 2005. It gives 5 pillars for reparations for gross human rights violations, which are restitution, compensation, rehabilitation, just satisfaction, and guarantees of non-repetition. I'll go into this a bit later as I unpack the remedies issued in this case. We can move to the next slide, please. So first, Article 1. My rewrite, essentially, for Article 1, the committee asks, did Mauritania take legislative and other measures? And it goes on to appreciate the 2015 Anti-Slavery Act and notes prosecution and finds a violation. Notes that the state did, have prosecutions and found violations, but the prosecution was inadequate. And in my rewrite, I look at Article 1 and how it cannot be satisfied by pointing to laws that leave hereditary slavery functionally intact. Yes, they had the laws in place, but the law did not automatically lead to implementation, right? And the committee, in its own analysis, basically says that the obligation of state parties in Article 1 of the Children's Charter, you can see this in paragraphs 54 and 91 of the case, it says that the obligation is one of result and not one of conduct. So yes, the state did take legislative measures. That's an obligation of conduct, but the committee was saying that the obligation here is an obligation of result. What is the result? The result is that we had 2 children who spent 11 years enslaved while the state did nothing proactively. The analysis cannot stop at how inadequate the prosecution was, but it must ask about the structural conditions that sustained it, and what does dismantling them actually require. So first, in my rewrite, there are 3 specific, should I say, sub-obligations under Article 1. First, the structural intervention, not merely laws, but dismantling the socio-economic architecture of caste, so the registration system, the landlessness, exclusion from civil identity documentation that enables slavery to reproduce across generations. Right? The fact that Said and Yad's freedom depended entirely on their own initiative in itself was a violation of Article 1, because it wasn't the state that proactively found them, it was them who escaped and then sought help. Next is the fact that what is due diligence actually measured by? The committee failed in expanding that adequately in my understanding. With regards we can move to the next slide on Article 3, please. So with regard Article 3 focused on, it's basically a non-discrimination, right? And the committee did find a violation that the children were discriminated based on their slave status within the El Hassin household. They were treated differentially, and But that is not sufficient. So in the rewritten version of this, it is grounding the analysis of Article 3, the Article 3 violation in says General Comments 29 on descent-based discrimination. So the inheriting caste, being a colonial construct, is systemic, intergenerational, rooted in Arab domination and French colonial governance. And so the committee missed the opportunity to adequately expand on that. And if you read Article 3 on non-discrimination and Article 21, 21 speaks about discrimination based on sex and other status. Emphasis here is on other status, right? So hereditary slavery is a harmful social and cultural practice, but the question, how is it reproduced, was missed. And this is because they got their slaveryhood by virtue of their mother status, which was automatically transferred to them. The matrilineal hereditary slavery is therefore a practice that the committee had an opportunity to name. Yes, the case was about 2 young boys, but looking at the broader implication and the potential transformative power of the case, there are many young girls who are in slavery and other young children who are in slavery by virtue of their mother statuses, right? And so even though the best interest analysis of the child could have covered this as well, it was just mentioned as a matter of fact that they inherited their slavery from the mother. But in the rewritten version of that analysis, my rewrite basically makes a centerpiece of Article 21 that the Charter cannot protect children from slavery while remaining silent on the mechanism by which slavery is reproduced across generations. And so there's also the unresolved contradiction in the original decision that makes mention of the mother being prosecuted alongside, which the committee did not by any means mention or address in its decision. And so I think I already mentioned said General Comment 29 on descent-based discrimination, where said committee explicitly confirms that it applies to caste-based discrimination. And so to reconceptualize heritage identity was an opportunity to contextualize as a structural legal category. We can move to the next slide, please. Because the committee's analysis of these 3 articles was, in my opinion, quite thin and did not adequately explore all the avenues it could, it reflected in its remedies as well. Yes, like I said, the remedies are quite long, about 15 or so remedies, a few of them focusing on guarantees of non-repetition, which are basically remedies that allow for the issue not to reoccur. However, some of the other type of remedies like just satisfaction were not met. So first, restitution. Restitution allows for the state to restore, to try and restore the person to the status they were before the harm occurred. And in the decision, they did extend some of the recommendations to other children to say name, identity, registration should apply to Said and Yad as well as other children who might be affected, generally speaking. In terms of compensation, it was just one recommendation. That was very thin, if you ask me. The committee basically framed that recommendation asking the state to compensate the children based on, how did they frame it? Commensurate to the violation they suffered for 11 years, but did not go on to determine what that would mean. And I do understand that there's a lot of scholarship around how regional bodies need to be careful in terms of granting the quantum of damages, as that might be one of the reasons they face backlash. For instance, the Ajafo decision, where this was, I think, at the African court actually, where they issued a recommendation of $66 million in favor of the applicant. And so I understand why the committee might be hesitant in terms of giving a figure, but it could have done more in at least giving a formula for how that compensation could have been. And in this case, I'm saying they could have given a sort of formula to say, okay, 11 years by the poverty endured, the regional poverty threshold multiplied by, how much harm they would have endured in that period, and also acknowledging the mother's harm chain and exploitation that she suffered that extends to these boys and other children within that context. Rehabilitation, the committee did speak about psychological support, accelerated education integration, which was okay, so no issues with that. But because there was no gender analysis in the violations, they missed an opportunity to extend remedies for a gender responsive remedy for girls and women exiting slavery, including survivors of sexual violence. In terms of just satisfaction, an official state, so just satisfaction, in my opinion, is one pillar of remedy that is significantly lacking in this decision, because the committee did not make reference to ways the state could set up a structure that speaks to the issue beyond the boys. For instance, an official state acknowledgement of the inheriting caste as a colonial construct and heritage slavery as a crime against humanity. That didn't come out in the recommendations. Another could have been a public truth-telling process, formal apology to the victims of this hereditary slavery in Mauritania, and that's completely absent in this judgment. And so that's one other area that the decision tries to rewrite. And for non-repetition, the committee did issue some recommendations. I spoke to that in terms of registration of childbirth, similar to what we saw in the Nubian case, but missed the opportunity to criminalize this matrilineal system of passing down slavery. I mean, slavery in itself is criminalized, but they could have criminalized that further, because that then means that even as we're in this room, before the next time we convene, there are potentially children who would be in the same situation as Said and Yad, because that particular aspect was not addressed by the remedial framework in this decision. We can please move to the next bit. So basically, this highlights what the contribution, the paper, the writing of the judgment is trying to meet. But before that, I'm going to just quickly read an excerpt that I've written to form part of the written judgment under Article 21 and gendered mechanism of hereditary slavery. The committee observes that the harmful practice of hereditary slavery as it operates in Mauritania is not merely a custom of exploitation. It is a system of caste reproduction transmitted through women's bodies. Said and Yad Salam are enslaved not because of acts they committed, but because their mother was enslaved. This is the mechanism that Article 21 of the Charter demands states eliminate. Article 21 obliges states parties to eliminate practices discriminatory to the child on the grounds of sex or other status. Matrilineal hereditary slavery is such a practice. It operates through sex and the caste status of the enslaved mother, transmitting her subordination to the children. The Charter cannot be interpreted to protect children from slavery while remaining silent on the mechanism by which that slavery is reproduced across generations. Accordingly, the committee finds that Mauritania's obligation under Article 21 extends beyond the prohibition of the practice as experienced by these two children to the affirmative dismantlement of the social and legal structures through which enslaved womanhood reproduces the condition of enslavement. So putting this together, there are four key jurisprudential contributions of this rewrite that adds to the committee's decision, the committee's body of law, as it were, not just to this case. First, it decolonizes the Charter's interpretive framework. The due diligence doctrine is currently applied by the committee. It was developed in the context of state torture and disappearances, not hereditary caste slavery. So importing it without adaptation allows states to satisfy Article 1 with laws that change nothing on the ground. So yes, legislative measures were taken, but they did not account for implementation. The Charter was conceived within the African context and must be interpreted as such to include persistence of colonial era hierarchies within formal independent states. Second, it expands Article 1 from legislative conduct to transformative results. It has implications beyond Mauritania. Any state where formal rights protections coexist with structural exclusion, where laws exist but caste, class, ethnicity determines whether laws apply in practice, faces a potential transformed view of the Article 1 obligation in this rewrite. Third, it names the gendered mechanism for slavery reproduction under Article 21. And for the first time in the committee's jurisprudence, And to my knowledge, within the African Human Rights Tribunal system, the rewrite identifies matrilineal hereditary transmission of slave status as a sex-based harmful practice requiring affirmative dismantlement. It opens the African Children's Charter to a feminist analysis of how caste reproduces itself and brings the Charter's language on sex and other status to bear on a phenomenon that has always been in plain sight. And then the fourth aspect, it establishes a reparatory justice template applying all 5 pillars of the UN basic principles, including satisfaction and structural non-repetition to this child slavery case. And so this rewrite sets a model for future cases of intergenerational exploitation as it challenges the committee to ask and make recommendations that do not just speak to whether the violations are being corrected, but whether the remedies are dismantling the conditions that make the violations inevitable. We can move to the final slide. In conclusion, I've come to the conclusion that formal abolition was never enough, as was the case in Mauritania, despite slavery being abolished since 1981, criminalized in 2007, and the amended law further, pushed on anti-slavery in 2015. Yet, Said and Yad spent their entire childhood enslaved automatically by virtue of their mother status, while the state looked away. The committee's decision recognized that something had gone wrong, but it diagnosed the treatment failure where the problem was structural. It prescribed corrective measures where transformative measures is what was required. And it was silent on the gendered mechanism through which the next generation of heritage children will be enslaved. And so in the case of Said and Yad, it gives us a window into how international children's rights law must become, if we're honest about structural power, gendered harm, and the meaning of reparations, these 3 themes that come to bear in this panel. My rewrite argues that the African Children's Charter already contains the resources for this transformation, starting with Article 1 as a transformative obligation, Article 3 as structural descent-based discrimination, and Article 21 as the provision that enables us to name the enslaved woman and the mechanism for caste reproduction, and then a reproductive justice framework that allows for accountability and remedies that actually speak to dismantling the conditions that make the violations possible in the first place. Thank you so much for your time. Looking forward to all the questions. Thanks, Prof.
Thank you very much, and thank you to all our presenters. We're a little bit behind the schedule, but I guess we have a few minutes for questions. Please try to keep them concise. Do we have anyone who wants to ask questions now? And yes, we have over here. Yes. Oh, okay.
Thank you. Good afternoon. I want to address my questions to the first 2 speakers. So they spoke very strongly about the need to invoke feminist jurisprudence in deciding some of the cases. So in the cases that they spoke about, I do agree that there was a need to invoke feminist jurisprudence. But my question is, as it was in the morning, is what will be the legal basis, the enabling framework that allows for the invocation of feminist jurisprudence? I ask this question because often the invocation of feminist jurisprudence in those cases brings about good outcomes in some of the cases, but we still have to have a legal justification for it so that we don't have a situation where the means always justifies the end. Then we've got a problem of judicial innovation and remedies that are difficult to understand in context. So, for instance, shortly, in South Africa, the South African Constitutional Court has been invoking feminist jurisprudence. I think in one of the cases in 2018, they found certain people guilty of rape when those people were not even in the particular room when the rape was being committed. They did not know that it was happening, but they were still found guilty of rape. And the court justified its decision as an invocation of feminist jurisprudence. So I'm just thinking, what safeguards are there for society if we invoke feminist jurisprudence in that regard? Because judges come out smelling of judicial roses, but there's always an impact on society. So basically, what is the legal basis that enables that jurisprudence to be invoked? Thank you.
Thank you. And we have a question online to Peter. One of the justifications for excluding daughters from succeeding to the chieftaincy, if women would succeed to the chieftaincy in certain circumstances such as widowhood, was that upon marriage, daughters would join a different family or lineage, creating the risk that this chieftaincy would pass outside the royal family. You use living customary law to engage with this proposed justification in your feminist rewriting. Are there questions, comments, or you're all tired? We're coming to the end of today's conference. Doesn't seem to be anything else. Do you want to make some reflections on this?
Thank you so much, Felix, for your question. Before I answer it, I want to start by reading the words of Rosemary Hunter. Rosemary Hunter was she's a professor that led the feminist judging project in England and Wales. And these are her words in as far as the nature that this rewriting should look like. She says that by working within the law at the time of the original judgment with the material available to the original judges and using standard techniques of legal reasoning, the written judgment demonstrates powerfully the contingency of the original decisions. They show that even at the time and subject to the same constraints as the original decision makers, the judgment could have been reasoned differently. The point I'm trying to make by drawing on Rosemary Hunter is to show that the rewriting of judgments, and if you read my full paper, and I believe my colleagues here, is we are still confined to the law that was applicable at the time of the decision. For example, when we were drawing on jurisprudence, on general comments that have gone ahead, we made sure to quote decisions, literature that was published or cited or released before the 4th of December. And so we are trying to show the judges that even at that time, that information was available to you. If you had the option to engage with it, but you didn't. Most importantly, the point that I made also was that using the court's own jurisprudence to pivot into feminist judgment. For example, when one of the decisions of the African court says that when making decisions, they will look at the circumstances of each case. That language in itself resembles the language of one of the feminist critiques that actually says that when we are deciding judgments, context should be a golden thread. Telling the story is a golden thread. So writing judgments, we are not just romanticizing feminist jurisprudence. We are trying to locate, we are telling the courts, this is what you said, you started this, can you please finish it? And there is actually jurisprudence that has gone ahead. The African Commission decisions are decisions that the African court itself can cite, right? So if the African Commission itself started the discussion on substantive equality, what feminist judging is saying, let's build on that. Let's just get into depth with what that is. And when it comes to writing these judgments, again, we are not getting information from nowhere. If the issue is about discrimination, automatically there is no way you will discuss discrimination and equality and just stop at formal equality. That in itself, as a judge, should help you pivot. And that pivoting means that if you are a well-versed judge, you have literature at your disposal, you have empirical evidence at your disposal, you have judges that have gone ahead at your disposal, you have general comments at your disposal. So you already have a framework, the Maputo Protocol itself and the Article 7 that says there should be
be no discrimination. And that in itself is a basis for you to pivot. So African feminist judgment is not saying invent new provisions, invent a new protocol, no, we are working with the system. That is why we are drawing on the judgments that you yourself have decided that you have refused to engage with to show you that you could have arrived at a different decision if you wanted to.
Thank you. There's a last question. You'll see that. What feminists want to achieve in Africa continent? Yeah, so I will echo with what my colleague has said, but I think so in my rewriting, I've also relied a bit in the South African Constitutional Court judgment as well, where they have been quite progressive. So what we want to say is that feminist jurisprudence does not replace the law, right? It changes the question we ask of the law. So the legal basis already exists in the African Charter, the Maputo Protocol, and so on. So what we are looking is simply a method of interpreting those existing obligations through the lived realities of women. So the safeguard is the law itself. So the feminist judging is not deciding cases because they concern women, right? It is deciding cases according to evidence, treaty obligations, and reasoned legal analysis, while making visible structural inequality that traditional legal reasoning often ignores. And we continue to have this conversation even as today we are speaking about tradition, religion, custom, culture, and so on, towards women specifically. I think women are the one that are the favorite attack. So now when it comes to the question that I got online, so I would say that living customary law does not mean preserving custom because they are old, but it means recognizing that customary law evolves with the communities that live with it. The question is not whether women marry. The question is whether marriage can legitimately justify permanent exclusion from public authority. So customary law has never been static. It has adapted to colonialism, to constitutionalism, to democracy, and changing social realities, right? So why should gender equality be the one development from which custom is exempt? So if women can inherit land, sit in parliament, become judges and head of state. So there's no principal reason why marriage should disqualify them from traditional leadership. So the question is not whether customary law should evolve. It always has. The question is whether it should continue to evolve without women. And this is not about preserving culture. It is preserving patriarchy if we continue in this kind of discourse. So yeah, I'll end from here.
Thank you. Henrietta, any final comments from your side? Even though you didn't have a specific question directed at you, but
no, not really.
thank you. Then I think we move over to our concluding session, because we're already a bit delayed. And I leave over to
Maybe we stretch our legs for just 5 minutes. There is tea here, but honestly, then we must not make it a. I mean, someone has said, we have lunches and teas all the time, but maybe it is a Friday afternoon, so just a quick break, fresh air, and then we're back in maximum 10 minutes, please. Is that agreed? Then we'll do the final session. Thank you. Yes.
Okay. Good evening, good afternoon. It's evening now, almost. Welcome back. Hey, Trevor. Okay, we need another one. We need another chair. Sorry.
They can grab one day.
Hmm?
I can do.
Okay. So then we have. Okay. Maybe just create space. Oh, it's fine. Yeah. Okay. So thanks again for coming, and we are on to the last session. I'm just gonna ask that you please pardon my voice. I am recovering from laryngitis, as I heard. Is it flu? I am going to facilitate just a very quick reflection round. So it's not really a substantive session, but it's also an important session in the sense that we get a minute or two to ask each of our panelists to have a reflection on the conversation since yesterday, and maybe some of the key takeaways from the conference. Because of time, we are going to be very brief. So basically, we are aiming for 5 minutes. If you can do it in lesser, even better. And so we are also going to change the format a little. So we are merging the last session with this session. So this panel will actually also be the closing. So to start us, I'm going to invite Trezor. Okay, so let me just say the order so that I don't have to stand and invite everybody again. So we're going to start with Trezor. He's very surprised. I don't know why he is. And then Maria, and then Magnus, and then Babatunde, and then Gina, and France will close. If I may, please request Trezor to start.
Thank you so much. I will be really brief. So for me, I have, think, two lessons that I got from this session. The first one is the interaction between what I would call the demand of regional human rights justice and the supply of regional human rights justice. All the discussion that we had actually turned around that. What is the quality of submissions that we make and who are appearing before these regional bodies? And for me, I see that as being the demand. And when the demand in those the rules of supply and demand in economics, when you have high quality of pleadings that are made, high quality of submissions, high quality of argument, I think on the other side also the court will try to make sure that it meets some of those arguments. It's also do further research. The supply side is also important. Who is on the other side? And when I look at some of the decisions that were discussed here, who is on the other side also means who is supporting them in terms of legal assistance and all the legal team working with all these judges. Sometimes when you discuss with people working at the court or working at the commission, they will be like, if you're close to them, I wrote almost half of that judgment. And you realize that judges did not play a huge role in that particular thing. So when we focus, we try to rewrite, we try to rethink how to do some of these things. We also look at the people who are behind the scenes. And some of those people who are behind the scenes our former colleagues, our former students, or sometimes our former lecturers. And this connects to the next one. And law, as Ronald Dawkins has always said, law isn't interpretation, how you interpret what you have. Sometimes you go beyond what is provided. You believe that interpretation is about creation. You can create and you can look at extra legal materials to improve the quality of judgment. Some judges would consider themselves as being activists, being philosopher kings, and prescribing, again, what society has to do in order to improve human rights. And others will, in the Montesquieu sense, believe that they are only the mouthpiece of the law. What they have to say is to technically interpret the law and not being more activist. So the judicial restraint and judicial activism, you see it, you see that the two dynamics reflecting in some judgments. Some judges believe in the judicial philosophy. They should go beyond what the technical role entails, and others believe that they should just be minimalist and resolving the question that has been posed to them, while we know clearly that human rights litigation goes beyond the parties that are present before the judge. It has also social, political, and economic impact. Thank you so much.
Thank you. Lots to reflect on. It's been a wonderful 2 days of insightful, reflective conversations. But just to summarize my thoughts in terms of where we land, I think, first of all, we must remember that law is made for man. It's not the other way around. Man is not made for the law. So one of the roles of the law is to advance us as a people, as a society. So whether it's in terms of what a landmark is, rewriting possible judgments, imagining what could be a better scenario, and all the keywords that have been coming out in this past 2 days, words like Afrocentrism, what is illumination, decolonialism, transformation, and all of those things. I think the questions we should ask ourselves, especially from the African perspective, is who are we as a people? What kind of a people do we want to be? What kind of a society do we want to live in and to create for ourselves? Why do I say that? We're very quick to point at the history, the colonial did this, did that, and that. But the question is, given the kind of laws we have, the commission, the courts, and the roles of these bodies, what are we doing tangibly to move the conversation and the realities away from that history? So whether it's in terms of culture, social construct, social cultural issues, it doesn't matter, religion and all those things that we've talked about. There is always room for all of those things as a part or a form of our identity as individuals, as peoples, as a people, or what have you. But there is absolutely no room for any of those things to be used to perpetuate harm, violations of human rights, or to in any way set us on the path of retrogression. And I think when we hold those at the backs of our minds, then it will be a guiding framework in how we engage with these laws, these bodies, and all that we want to set to do. Thank you.
What's next? These 2 days we discussed landmark and rewriting. I was been a bit confused about landmark. I mean, why do we really need it as a category? For me, it's only really I do a selection for a compendium of key human rights documents of the African Union. What should get in there? I mean, I guess that's then landmark stuff that should get in, especially since it seems to have a quite broad sphere here as it's been interpreted over these last two days. But on the rewriting, how do we? I guess the aim there is, well, we shouldn't need to do it. We should get the judgments to be better to start with. And of course, one gets intrigued. I mean, like Shita was quoting from the dissenting opinion in the Lesotho case, which I guess is the best illustration to why they never really do dissenting opinions at the African Commission, because it's a really horrible piece of writing. So perhaps it becomes better when it's when it's collective writing, even if it's written by the secretariat in many instances. So, but the improvement there, I guess, comes in from, I mean, how do one get in both how well trained counsel is into bringing in all the issues that one wants, the amicus, but I mean, then also having access. So, which I mean, for the African Commission is an issue in relation to how the cases are available before they come up for decisions. The clerks and the secretariat staff, I mean, how the training that exists there. Yeah, I think those were my reflections.
Oh, thank you. Thank you. Yes, although I was not here yesterday, but from the papers read today, and of course, just by looking at the program itself, I think one key thing that comes to mind is that the idea of even looking at rewrites, or what I would call critical rewrites, because I come from the critical approaches to international law school of thought, is the need, or is the importance, the imperative of allowing ourselves to imagine anew, to kind of have, counterfactual imaginations, to reimagine the kind of world we want. And I think it is very, very important that law by its very nature is very elitist, and very, very, very conservative. If you look at some of the writings, African scholars have been writing about this for years, about how the reason why we are not kind of coming to the position of critical approaches is the fact that the way our law schools have been set up, the way our universities and the kind of trainings those who become judges and those who become law professors get. And that actually limits the ability to imagine, to kind of ask ourselves critical questions. Could we have it another way, or could we have it in a more kind of progressive or in a more convivial way? One former student of mine told me, Jose, he said he confessed, that was his confession, that when he saw that I was writing about music and international law and things like that, of course, he's older than me. He said he thought it was youthful exuberance, that I was just being irresponsible as a human being, that he probably even thought to himself, like, how come this guy actually supervised me, this irresponsible person? But anyways, of course, perhaps he's now seen the light, so to speak. But to just say, let's imagine anew. And one of the things maybe I would have loved to see, or perhaps if I had time, I would have loved to present at the conference, would have been, kind of an imaginative kind of judgment, or kind of what I would call a necro trial, kind of a posthumous, something along the lines of what I'm not sure if you guys have read The Trial of Cecil John Rhodes by Adekayi Adebajo. Fascinating novella, and building on that and kind of bringing people from the dead and kind of trying them and making them answer questions. And, so for me, the bottom line is this is just the beginning of the conversation. We should allow ourselves to, to be able to reimagine or imagine anew, so to speak. So thank you very much.
Thank you very much. I'm debating if I should first give the two of you, whether I should then probably just take contributions, one or two from the audience. If you have anyone has a reflection that you think is probably not captured or you would want to speak to. Before I give to Gina and Franz, because then we'll finish. Oh, there, okay. This one, or which one? That one. Oh, okay, I see you, Michael, as well.
Yes, so thank you so much. So my own reflection is
because something that was consistent all through the presentation is compliance. Then I started asking, so how then can we make states to comply with decisions? Then one of the things that struck me is actually linking the election period, because I think one of the challenges we have is the quality of leaders that we have in politics. And at this point, it's so evident that we cannot separate politics from law if we actually want results. So I'm thinking, I know that African states are not the same. At least there are still some reasonable African states where the electoral process works, e.g. Ghana. So I'm thinking that at least starting from the low-hanging fruit, to use, if there are the human rights indicators as part of the means to challenge the government of the day during election period. And then that means that the people, then how to make them get more informed. We have a lot of them getting informed on these decisions that are not being implemented. Then during election period, then, engaging states on these issues. And I think human rights basically, especially for enforcement of decisions, should be part of issues that we use during election period to actually engage government of the day, especially those ones that are seeking re-election. So I think we should not, at this point, if we really want results, there is no way we can achieve anything by separating politics from human rights. Yeah.
Okay, thank you very much, Michael. I'm wondering whether he's... Oh, there's two Michaels. I meant that mic.
Thank you so much. So for the past 2 days, I've also been reflecting on rewriting judgment, and especially today. And I realized that all the various judges, including us as scholars, we represent different constituencies. So I've been asking myself, if I happen to be one of the judges and I'm contending, or I'm sitting on the bench with maybe 8 others, making it 9, where we also deliberate on the issues, the evidence, will I be able to offer the same conclusions or the same argument that I'm making? Because at the end of the day, there's going to be different debates and the rest. And just as she was saying, you can't separate law from politics. So 2 experiences that I've had. 2 years ago, I was serving as an advisor to a case, an environmental case in the High Court in Ghana. And in one of the deliberations, the judge was asking us that she feels challenged by the evidence, but then she's asking, if she rules in our favor, do we think the state will have the resources to be able to implement what we are asking for? And I think this is one of the things we have to also ask ourselves, that as we are reimagining some of these decisions, we should benchmark them to where we are as a continent, where we come from as a country, that if a supranational court issues a judgment, do we have resources to implement them? And then to conclude, sometimes I feel these judges make decisions intentionally, but they decide to intentionally be constructively ambiguous because they don't want to offend our political elite, the various countries, and they also don't want to face the wrath of African citizens. So then they choose
the middle ground, what we call constructive ambiguity. So as we reflect, let us also consider some of these things so that the decisions that the judges make won't be too heavenly. Thank you.
Okay, I have a few more minutes, and I'm going, in the interest of fairness, I'm going to also ask someone who is online. I see a hand online, right? Wow, now interest is spreading. Um, 1, 2. That's the two ladies, so I can, I can balance out. But there is someone online first, Achilles, I think.
Yeah, thank you. Thank you very much. And thank you to all the panelists. Yeah, I think just my reflection that there is some sort of a connection between judgment writing right up to the level of compliance. So I think one of the issues I've identified is the lack of judgment writing training. I feel that the legal officers, right, from junior legal officers to senior legal officers, as well as judges, need yearly training on judgment writing. Yeah, because a bad written judgment will likely suffer from issues of compliance, as many states will tend to, decide to not implement the judgment. Thank you. I think that is just my very brief contribution.
Okay, thank you very much. Briefly.
Okay, so I'll be very brief. Hello, everyone. So I've just been considering the whole aspect of rewriting judgments, but specifically the aspect of the fundamental tension that exists between academic theory or scholarly critique and that being translated in a sense into practical law, into reality. So how can we really reconcile these two in a sense to ensure that we move beyond words and we see this really actualize. We see this in future pragmatically. So yeah, thank you.
Thank you very much. Yeah, you can pass the mic. Good afternoon, everyone. So I just have one observation, and is in respect of the trend that we have seen, member state pulling back from the court when judges push boundaries. So is there a risk that enforcing a feminist approach will cause further backlash? And then also whether this feminist approach, we can also say that there is a role that a judge also plays in issues relating to being a neutral arbiter, because you have to also, one has to consider both parties, that is the state as well as the victim. And even if you look at the case of Elisa versus Tunisia, you'll also realize that the judges were very mindful and also consider to some extent the issue of substantial justice, because they have confirmed the fact that, yes, they are not an appellate court, but they went into the merits of the case. And I think that there was a balance of rights in that case to some extent. Thank you. So having taken the questions online, and so maybe just one reflection before I hand the mic to Gina and Franz. I was not here yesterday, and I've only just come in the last session. So I did catch the conversation around feminist approaches, and I hear the question, and I also see a comment online that says that maybe it's addressed to us, that perhaps we should introduce rewriting judgments, decolonial and Afrofeminist perspectives. And well, I can't make a decision on that, and Magnus and Franz are here, they can decide. But just thinking, I think and also maybe I should say we are in the process currently of having a study on how regional courts have approached gender in decision making and the use of from a feminist perspective, just a review of decisions of the mechanisms from the region. And one of the things that is very clear is that to those that are aware and conscious to feminist reasoning, there is a very clear gap. And to those that are not conscious of it, it's a wild and strange idea. And what value would it add? And I think that in itself communicates a need to explore what would a feminist perspective, and feminist, not only feminism, but I'm speaking about feminism because it's something that I have a personal interest in. But I think there is some value there for exploration of what actually could change in the jurisprudence. And maybe just while on that, to just say, feminism is not necessarily about women. As my friend likes to say, feminism is the very radical idea that women are human beings. That's all. So the rest of it it's very easy to actually see how a theory that derives from equality of people can influence judgments, not just for women, not just to bring a feminist perspective, but to actually ensure balance of judgments for everybody. So yeah, I think I have heard a lot in a panel that started by saying they don't know what they're going to say. I have written 2 pages of notes from just the reflections of each and everybody that is here, which tells me it's been a rich 2 days and that there's a lot still to explore in the period that comes. And with that, I want to request Gina to share her reflections.
So one of the benefits, or perhaps not benefits, of being one of the last speakers on this panel is that I probably really do have very little to say. I think everybody else has already said much of what I wanted to say. I think the only thing that I would note perhaps is that running sort of quietly, persistently throughout both of these streams, the landmark judgments and the rewriting judgments streams, has been a deeper question about institutional identity. So what kinds of institutions are the African Court, the African Commission, and the African Committee on the Rights and Welfare of the Child? What roles are they actually playing within the continent's evolving human rights architecture? And I think perhaps most importantly, what kinds of landmarks might these institutions themselves ultimately become? And I think that's pretty a bunch of questions.
Thank you very much, Gina. Yes, I think I could just say, are we enough to form a quorum? Then we can just say, I concur, and then we have a decision, right? But just maybe going back, Gina, to where this all started for us, and perhaps saying that I thought we may have had 2 objectives. Generally speaking, just to raise more awareness about the decisions of these 3 bodies. And I think that generally speaking, it's true that we just do not take these bodies seriously enough. I was really confirmed in that when we received perhaps more than 200 abstracts, but they were rehashing OGIEC. We had 3 OGIECs here, but there were 17 OGIECs and ECHO, like Endorois and maybe SERAC and so on. There was actually very little surprising novelty. And there are so many decisions out. I know there are reasons, the accessibility of the African Commission decisions and so on. But I thought that perhaps we have alerted each other to the existence of some cases. I'm sure we've heard about cases that we have not read, and perhaps we're inspired to read further. And that just, for me, it's about our role to make this more accessible. And, I'm on to this idea of res interpretata, that once any of these 3 bodies have interpreted, that's kind of authoritative pronouncement that should be further shared and in a sense made kind of almost like doctrine. It's as weighty and as powerful as the treaty provisions in these cases decided for one particular country should be made accessible rules or converted into accessible principles, right? So how do we as academics, as scholars, to use a loaded term, how do we digest all of this and convert it into these formats that can be useful, more useful to judges? Because I think one of the landmark criteria that we also said is maybe when these decisions of the African Union institutions are actually taken up at the national level, right? So how often does that happen? They are so so few cases, examples of that. So how can we contribute, and maybe, hopefully through the publication and through this process, we've contributed to that. The other thing I think was a starting point was, yes, we want to see more transformative judgments in feminist jurisprudence and in terms of eco issues around the environment. But it was a starting point for us to say, how can we see the African jurisprudence becoming more African rooted in terms of the use of sources and incorporating understandings that are African and ways of seeing. That has come out very clearly in the conference. But I was reinforced by the importance of this when I marked a thesis just the other day from a student within our circle who wrote about self-determination. A self-determination thesis written in the beginning of this year that does not mention the Mansa case, that does not mention the case that has all the ICJ cases, all the decisions of the African Commission that are more historical, but does just not refer to the African Court's decision. Clearly, there's work to be done in terms of looking into the African examples that are in front of our eyes. But I think the point has been made by others that it is as much the task of those who plead in the choice of cases in the first place. Which cases do we happen to bring to these institutions, and then how do we present them? Is it for us? Surely it is for us to invoke Ubuntu and African philosophy as ways of reinterpreting, of seeing. In the first instance, we cannot expect perhaps the judges and their legal teams to come up with those. So I feel very inspired by what we heard and what we shared here, that we're on the way, and each of us, I think, will rethink our role in creating greater awareness and creating greater African rootedness in our work around these systems. So those are my few thoughts, but if you would permit, Madam Chair, to just say a few words about the way forward. I think those who are presenters, you would understand that you are expected perhaps to now integrate all of these wonderful comments, and by the 31st of July, maybe we'll communicate with you to give us a revised version. On the one hand, a number of the papers in the landmark part will be considered for the African Human Rights Yearbook, and then in terms of the rewriting judgments, we will work towards an essay volume that will contain those. So we will reach out to you. It is clear that not all of these papers, perhaps especially in the landmark section, would be able to be published because there are limited space. So we will, also have to see how that process unfolds. But we encourage you, and we will communicate with you formally as well. And then lastly, just the very heartfelt words of thanks. First of all, from my side, from the Pretoria side, to Gina, who really was the one who had the first brain moment, the spark to think about rewriting, and that propelled us into action and brought us here. So thank you. It was a pleasure, Gina, to work with you on this, and to now work with you in the future onto this as well. I'm very sure it will be a great pleasure. And I think Tresor, working with you now also on the yearbook and on the further development of those papers for the landmark part. I also want to say thanks to all the presenters. You are the ones who made this conference what it is. I think it was wonderful contributions from all of you, and we look forward to walking the road further with you. To the chairs who were here to keep us on the straight and narrow, and then also all of you who participated, all of you in particular online. We really appreciate your presence. We see that there really was a great interest and consistent presence from people online. So thank you very, very much. And then from an organizational point of view, just to say thank you to the team here. I have to first mention Tenet. Tenet is the one who on our side was really the one who held it all together and communicated with you and kept track of every eventuality. Thank you so much. It was a pleasure, Tenet, to work with you closely, supported by Pumeza, who's part of also the team here with us. We are really a wonderful team. And then Liam and Cassius and Lasane who are there, but everyone playing their own part. So thank you very much. Others in the Center for Human Rights, we always say it's a team effort. David was here for the photographs, and Simpiwe, as always, here with the technical assistance and everyone else from the center side who's been here. We really appreciate your assistance and your contributions to making this the successful event that it was. And thank you once again also for each of you. And I don't know, Chair, if you want to have the last word, but we can maybe just wish you all safe and good journey back home. And we always keep whoever we've been in touch with as part of the greater center alumni circle. So if this was maybe a first encounter, we trust that we will be staying in touch, and everyone else, we will just keep on doing the work together with you that we believe in, that is worth doing. So thank you very much once again, and good wishes and good journey back.